Next time, sir, इसको ध्यान दो.
Yes.
Wait, please, Your Lordship.
Yes.
Lordship, I beg to mention item number 6 to 10, Lordship.
6 to 10.
Lordship. Lordship, conducting counsel, Mr. Pangin is out of station today, Lordship, due to some personal difficulty, Lordship. Kindly, this matter may be taken up after puja break, Lordship.
For a very long adjournment. What says the representative on the prayer made by Mr.
D. Lona, Lordship.
D.
Lona.
Lona, the counsel for the appellant in criminal appeal 3 of 2022. Magistrates adjourned today. Oh, you are in all the cases? Oh, for the appellants. Since adjourned today. List after 4 weeks on a date to be fixed by the office.
Obliged, Lordship.
Your Lordship, in this matter, there was a matter of condonation or delay which has been granted. But I would also like to bring some facts to Your Lordship's attention. There is a related matter which, in fact, Your Lordship was adjudicated upon regarding a related matter regarding contempt in this matter. Your Lordship, that is in the Chief's bench, and that has been posted for January. Because the state has asked for extension of time in the original PIL. So I would suggest, Your Lordship, if you may think appropriate, it may be tagged with the contempt petition.
No, instead of tagging, you see.
Because your Lordship was actually one of the members of the bench.
We think it would be appropriate merely to adjourn the matter and on your prayer. If you want, you can apprise the Honorable Chief Justice and he may call the records instead of us.
Oh, I
setting
understand, Your
records.
Lordship. I understand the administrative approach.
So-
Your Lordship, one more thing I would like to bring to your attention. Since there is an order in that matter and they have asked for an extension there, and here they are saying the road is completed, I may be allowed to bring that on affidavit on record in this matter.
You do it, nobody is stopping you. Don't need a-
I need permission. I can't just file something.
No.
Okay,
To do it, if you want to bring it on records, the subsequent development, you
Yeah.
can always bring on record.
we'll do that. In that case, Your Lordship, this may be adjourned in January.
Yes.
But notice may be issued in the meantime, Your Lordship. The notice is yet to be issued.
You have Mr. A. Kashyap,
Yes, Your Lordship.
but Mr. A. Kashyap and counsel for the appellants. Also heard, please for the respondent, you are there.
I am for 1, 4, 5, and 6.
1,
4, 5, and 6. One is
also heard Mr. G. Tarak, Standing counsel for respondent number. Please say again.
RWD. RWD, standing counsel for RWD. Rural Work Department.
The Rural Works Department, representing respondent numbers.
1, 4, 5, and 6.
1, 4, 5, and 6. You're also appearing.
1, 2, 3, and 7.
2, 3, and 7. Miss
E. Tanisha,
E.
Sangeeta,
Learned Government Advocate appearing for respondent numbers
2, 3, and 7.
2, 3, and 7. Explanation notice on this appeal by which the judgment and order dated 11/8/2023 passed by the Learned Civil Judge in WPC 198 AP of 2020 is assailed. Next, the Learned Counsel for the appellants has submitted that in a connected contempt petition, the responding authorities have sought for extension of time to comply with the order of the court.
In PIL 101, by way of an IA in PIL 10
PIL
101 of 2013.
113. Literally 4 weeks. Next, affidavit in opposition, if any, by the respondents, be filed by the next returnable date. Next, the Learned Counsel for the appellant submit that there is a subsequent development and he creates leave to file an affidavit to bring on record subsequent development. Also, there is a next list after 4 weeks.
Chabla, your lordship.
Met me, similar.
Yes,
I am appearing in item 3, 4, and 5. Well, in this case, my lord,
just a moment. Yes,
well, in these 3 cases, the validity of section 16(4) of the Central Goods and Service Tax Act was challenged. Now, by the Finance Act of 2024, my lord, section 16(5) has been inserted. And if it also just looks into section 16(4),
Mr. Kato, but last date you had submitted that there are similar issues pending before this court. What has happened on those cases?
well, the amendment has come by the Finance Act of 2024 for taking care of, and thereby the thing will survive. If your lordship just looks into section 16(4), my lord,
Page?
in the section 16(4),
Oh, section 64.
16(4), my lord, 16(4), 16,
16(4), yes.
my lord, I quoted it in page 11, my lord. Page 12.
Yes,
It says, my lord, a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services or both after the due date of furnishing of the return under section 39 for the month of September following the end of the financial year to which such invoice or invoice relating to such debit note pertains or furnishing of relevant annual return whichever year earlier. But there was some delay, my lord, in filing of the return, and thereby the input tax credit which was claimed by the petitioner was disallowed. Now, by the Finance Act of 2024, my lord,
Yes,
you will also kindly see section 118 at the second
118.
118.
Yes,
In section 16 of the Central Goods and Service Tax, with effect from the first day of July 2017, after subsection 4, the following subsections shall be inserted, namely, notwithstanding anything contained in subsection 4 in respect of an invoice or debit note for supply of goods or services, or both pertaining to financial year 2017-18, 18-19, 19-20, 20-21, the registered dealer shall be entitled to take input tax credit in any return under section 39, which is filed up to the 30th day of November 2021.
yes,
So, my lord, by this amendment, the input tax credit has been allowed to be taken if the return has been filed before 30th day of November 2021.
yes.
Now, in all the cases, my lord, in my cases, the returns were filed prior to 30th day of 2021.
Okay,
But in view of the earlier provision, my lord, the same was disallowed.
yes.
Now, this has been given a retrospective effect from 1st July 2017.
So,
So, my lord,
so you want to say that your application which was filed earlier should be considered by the government?
my lord, the order was passed, so my respectful submission before your lordship will be developed that those orders may be set aside, maybe matter may be remanded back to the adjudicating authority to pass necessary orders in the light of the new provision of section 16(5) of the Finance Act 2024.
Okay.
Then this.
Mr. Kato,
Well,
do we pass a judicial order to set aside the impugned order, or you will suo motu recall that order?
Madam, appropriately, madam, my plan is appearing on behalf of the madam.
Okay, for GST, you are appealing.
Madam. Allow this also, madam, my submission is, madam, once the madam, this amendment is come, madam, the proceedings against the petitioner will be automatically dropped, madam.
No, that we don't know unless the state makes that statement.
My lord,
Resume.
I have an instruction that the matter may be remanded back to authorities. They will drop the charges
Okay.
because they are covered under this new amendment act, my lord.
Okay. Okay, we'll dispose it off.
My lord.
Set aside the impugned order and then remand the matter back.
My lord.
The authorities for fresh consideration.
Consideration in the light of, my lord, section 16(5) as inserted by the Finance Act of 2024.
Yes, yes,
My lord.
yes, yes. Dr. A. Saraf, Senior Counsel, assisted by
T.Y. Bhutia. T.Y. Bhutia. T.Y. B.H.U.T.I.
Okay, T.Y. Bhutia. Okay. Mr. M. Katos is DSGI and Mr. A.
MK Boro, my lord.
Kiboro, then standing counsel for the
Senate Council, Central Goods and Service Tax,
Huh?
Central Goods and Service Tax, CGST and
CGST.
Customs, my lord.
standing counsel for CGST. Okay.
Well, shall I prepare a chart that the different petitions and the date of the order and the below the election number so and so for the convenience?
That would be handy.
Well, I will prepare it and send it by mail to the registry, my lord.
Yes, you send it to the court master.
My lord. That will be easier, my lord. Convenient for your lordship.
Take the email address and send it.
My lord, I am grateful to your lordship.
Otherwise, my lord, in these cases, my lord, where high courts have already upheld the validity of all this section 14 and all this, Patna High Court, even Chhattisgarh High Court also. And one part of matter is in pending in the Supreme Court, my lord. That part is there.
No, that
Yes,
will depend
yes,
on
yes.
what order the assessing officer will pass.
Yes, my lord.
Because right now there's an amendment. You'll have
My lord,
to
yes, their
do
amendment
the
was
exercise.
later made.
What happens thereafter, we'll see when it comes.
My lord. Hello, bless.
Operating against us. So this matter may be listed for 18th, day after tomorrow. Most of like.
My pleasure, Lordship. I'd like to mention RSA 2 up to 23 for tomorrow. Because this matter actually, yes. Day after tomorrow.
Lordship, I beg to mention item number 7. Lordship, conducting counsel for the petitioner, Mr. A. Tatak, is unable to attend the court today due to medical issues. Lordship, kindly matter may fix for 25 of this month.
Your Lordship, I'm appearing for.
Yes, Lordship, concern and second from other parties. 25. Obliged, Lord.
Lordship, I'm appearing for respondent number 3 in this matter.
Your Lordship. Your Lordship, I beg to mention a pending bail matter to be listed today. Bail matter. Bail. Bail. Yes.
We have to make a mention before the other bench.
Obliged.
Please, Your Lordship. I beg to mention item number 22. On behalf of
You've taken consent of the other side?
Yes,
Yes, Your Lordship.
I'm for the respondent number 7, Your Lordship.
Can it be fixed after vacation? Immediately after vacation.
Why is such a long adjournment? These are contractual matters.
Yes, Your Lordship.
Why a long adjournment?
Lordship, otherwise,
There's a stay operating.
There is
no stay
order, Your Lordship.
Huh?
There is no stay order.
There's no stay order.
yes, Your Lordship.
Both sides are represented on the prayer made by Recruitment Counsel for the petitioner. The matter stands adjourned today. List. After 4 weeks on a date to be fixed by the office.
Deeply, Your Lordship.
And the blue.
Yeah, please, Lordship. Lordship, this is a transfer matter, Your Lordship. Lordship, the implement transfer order is at page 22. Wherein, Your Lordship, my name is at serial number 3, Your Lordship. I have been transferred from SEPA to Raga Division as EE. Vice 1, Mr.
Where is the order?
Page 22.
This is the impugn, your lordship.
Yes,
I have been transferred from SEPA Division 2 as Executive Engineer Raga Division, your lordship. Vice,
your serial number?
serial number 3, your lordship. Vice 1 Engineer Hilang Tajul, who is the respondent number 3 here, your lordship. The said impugn transfer order has been initiated, your lordship, on the basis of a note initiated by Honorable Home Minister, your lordship. That is at page 23, next page, your lordship. In the said note, your lordship, the respondent number 2, who is the Home Minister, your lordship, has initiated this transfer order and specifically brought the private respondent number 3 of his own choice at the place of, at the present place posting of the present petitioner, your lordship.
Who is appearing for the respondents? You are there.
In this matter,
You are transferring a regular executive engineer and bringing in what you call.
Your Lordship, in this matter, AAG Aris Nabum is appearing. He's just coming on exit.
Okay. Let's wait for some time.
Lordship, in the said note, your lordship, specifically the private respondent number 3.
Let me start.
Lordship.
Mayor, please, Lords.
Yes.
My lord, the issue in this writ petition is, my lord, whether the family pension of the petitioner can be freezed, my lord, by the respondent bank in the instance of incomplete apartment, my lord. My lord,
You see, there is a judgment by, if my memory serves me right, there is a judgment by Justice P.K. Mushari.
my lord.
There he has held, after referring to a few judgments, that the pension amount, when it comes to your bank account, it mingles with your own account. And therefore, it is not identifiable. It no longer becomes a pension. The money which comes to your pocket
My lord.
mingles with the other money which you are having. Therefore, it's not a pension which is being attached, but it is your money lying in the bank account which is being attached.
My lord, to that, my lord, issue, my lord. There is one judgment, my lord. Hello, this is,
Which paragraph?
hello, paragraph. I've marked. That is my copy, I think, my lord.
It's okay.
Yes,
Which paragraph?
paragraph, my lord. My lord, paragraph 24 onward, my lord.
Paragraph
24 onward.
24.
Yes. My lord, married.
No, this is a case where this pension was converted into fixed deposit.
Yes, my lord. But my lord, the paragraph 25, my lord, it says, we also agree with Mrs. Soba that the High Court could not have gone behind the decree in the execution proceeding, and the alteration in the manner of recovery of the decreed amount was erroneous and cannot be sustained. We also agree that with with such and such that even after the withdrawal benefits such as pension and gratuity had been received by the applicant, they did not lose their character and continue to be covered by provisos G to section 61 of the CPC. Except for the decision in Jyoti Cheat Fund and Finance case Supra, where a contrary view was taken, the consistent view taken thereafter support the contention that merely because of the fact the gratuity and pensionary benefits has been received by affluent in case it could no longer be identified as return benefits paid to the appellant. My lord. Although, my lord, this pension amount is, my lord, remitted to the account of the petitioner, my lord, it doesn't lose its character, my lord. It will remain as the pension amount. And that can be, my lord, identifiable with other deposit if that is made in his her account. And my lord knows, my lord, there is a statutory bar to attach the pension, my lord, or pensionary benefits, my lord, under 61 of PPC as well as
This doesn't help you in any way.
my lord.
You see, please come to paragraph 3.
My lord.
Come to paragraph 3 of this judgment you are citing.
My lord.
In paragraph 3, how this money is to be recovered from execution is given.
My lord.
And therefore, when the trial court, the executing court went for a different mode of satisfaction of decree, then the Supreme Court says that the executing court cannot go beyond the decree and satisfy it contrary to the terms of decree.
My lord. My lord, there is one more judgment, my lord. Relying on this, my lord, Radhesam Gupta case, my lord. My lord, although this is, my lord, the judgment from, my lord, Telangana High Court, my lord, but that has been, my lord, relied. And in this judgment, my lord, it was directed to release the pension amount of the petitioner.
Show me the
After,
judgment.
yes, my lord. Yes,
You see, the first judgment in those cases
yes, ma'am.
is AR 1976 Supreme Court 1163. Followed by another judgment. This is a judgment by two judge bench of Supreme Court of India.
Alright.
And the judgment, the quorum of the bench is Y.V. Chandrachud, former Chief Justice of India, and V.R. Krishna Iyer. This judgment is authored by Justice Krishna Iyer.
Alright.
There, it has been laid down that the characteristics of pension remains so long as it is there with the government. It changes its color when it comes to the hand of the employee. So therefore, till the time when this money is lying with the government as a pension, it is free from attachment.
But my lord, in my humble listening, my lord, in this Radisson Gupta case, my lord, and which is relied in this judgment, my lord, relied by the Telangana High Court. My lord, para 6, my lord. 6 is start from para 6, my lord. Paragraph 6, my lord.
6.
Yes, my lord. There is no dispute regarding the position of law that pension account cannot be frozen or attached as per section 61G of CPC and section 11 of Pension Act 1871. However, the dispute in this case is whether the pension account of the petitioner is an exclusive pension or not. Same issue has been cropped up in this case also. Now, my lord, paragraph 7 is a fact of the case, my lord.
Same thing, you see, the judgment which I am citing,
Yes, my lord.
Jyoti Chit Fund, is referred here in paragraph 10.
Yes, my lord.
Very
This
clear.
Radisson Gupta case also there has been.
In your judgment, the judgment you are citing, see
Yes.
paragraph 10, very clear.
Therefore, my lord, kindly see paragraph 9 also. Paragraph 9 also. Paragraph 9, my lord, this Honorable High Court of Telangana has go to the extent that, my lord, since, my lord, this pension is property. It's come as a property.
You
and
see, please, when you read
please,
the paragraph, read the last line of the 3 lines of this paragraph.
Yes,
9. It follows that an attempt of the petitioner to take away part of the pension or gratuity or leave, even leave encashment without any statutory provision under the umbrage of administrative instruction can't be countenanced. So therefore, it is by way of an administrative order that was sought to be taken away, which couldn't have been done.
yes, my lord, therefore, my lord, yes, my lord, there is a statutory bar under, my lord,
How do you overcome paragraph 10? You show me a route to overcome paragraph 10, not one
can we
judgment.
come to paragraph 9, my lord? Last,
You read last 3 lines, it goes against, doesn't help you.
yes, my lord. Therefore, my lord, basing on this, my lord, 2 judgments, my lord. My lord, they are, my lord, the bank, the respondent bank was directed to, my lord, decrease the, my lord, pension account of the petitioner.
Mr. Rampai doesn't help you in any way. Please come to paragraph 1 first.
Yes, therefore, my lord, yes.
Read paragraph 1.
My lord, in my humble submission, my lord,
No, no.
let notice be issued today, my
Humbleness
lord.
will
I will
come later
satisfy
on.
this honorable court, my lord.
Humbleness is the second
Yes.
thing. Come to the primary thing of the question of law.
Yes,
Read the first line. Agreed by the action
Yes,
of the
ma'am.
respondent Union Bank of India in freezing or blocking the petitioner's pension account. So earlier times in the bank, it was permissible to have a separate bank account only for pension
Right.
fund. Nowadays, we don't have that. Because even if there's a pension fund account, but once it's transferred, it mingles with the fund of your own. That is what paragraph 10 says.
But my lord, that can be, my lord, that monthly pension can be, my lord, identifiable.
No, you see, I won't remember
Yes,
so
ma'am.
much.
Yes, my lord.
I told you that the judgment of Honorable Mr. Justice P.K. Mushari on the same point. this contention was rejected.
My lord, at this moment, let notice we issue, my lord. I will, my lord, try to convince this honorable court, my lord. Other than that, my lord, there is no any other clear.
Mr. H. Lampil under counsel for the petitioner. You are there, Mr. Kato? In this matter.
In fact, respondent number 2 have their own, standing counsel. I'm for
No,
respondent
Union of
number,
India is there, income tax.
my lord.
You're not appearing for income tax?
My lord, I'm told, my lord, they are basic, Guwahati-based lawyer, man.
I will, my lord, take a statement.
And State Bank have also, my lord, standing counsel.
The attachment of amount lying in the bank account of the petitioner is sealed in this writ petition filed under Article 26 of the Constitution of India on the ground that the family pension receivable by the petitioner is credited to the said account. Next, issue notice, including notice on the prayer for interim relief returnable in four weeks. Requisite extra copies of the petition be served. The petitioner shall take steps within 2 days for service of notice on the respondent by registered post with AD. So in addition, the notice on respondent number 1 shall be served by way of justly by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. Give a date after 4 weeks. Giving your citations. Yes, we are transferring,
I'm sorry, my lord.
we are transferring a full-fledged executive engineer and bringing in a in charge executive engineer. Why?
My lord, there is no any such guidelines or rules which prohibits, my lord, the officiating executive engineer, my lord, cannot be made, my lord. My lord, the another problem here is, my lord, he has submitted the representation and it was not given sufficient time to the concerned notary to, my lord, go through it, my lord. Your lordship may kindly see the representation that, my lord.
Because you see, after the home minister makes a note.
My lord, he's a local
No authority in the state would be willing to pass an order.
My lord, there is no any bar, but for the local MLA to make a recommendation. After he is a public representative, my lord.
That is there, but
That is there. My lord, may I just suggest, my lord, the prayer number 2 may be allowed, my lord. Lordship, see the prayers, my lord.
prayer number 2, that is that
Prayer number 3, my lord.
representation.
Yeah, my lord, that can be done, my lord. It was submitted only on 3/9, my lord. We are in 16, my lord.
Okay, how many days more you need?
हल्का ठंडा ले ऐसा है हाँ
If your lordship see the representation date, my lord, 10/9 to My lord, I was referring to my representation, my lord, page 26, my
How
lord.
much time would you need?
My lord, at least 1 week, my lord, another 1 week, my lord. This is dated
then-
10/9, my lord. We are in 6.
We suspend that transfer order.
Till then, your lordship will pass status quo order because it's a cross transfer, my lord. We don't know, my lord. It's a cross transfer if your lordship sees, my lord.
But Mr. A.K. Singh, Learned Counsel for the petitioner. And Mr. R.S. Nawam, Learned.
Respondent number 1, my lord.
Yes, Learned Additional Advocate General for the state representing respondent number 1.
Yes, my lord.
The transfer of the petitioner. So page 22, Lordship. Page 22. From the Office of Executive Engineer, SEPA Division, Department of Urban Affairs, to the post of Executive Engineer, Raga Division, Vice
Respondent number 3, my lord.
Respondent number 3
Yes, ma'am.
is by order dated 3/9/2024, issued by the Commissioner, Urban Affairs within bracket, Government of Arunachal Pradesh, is assailed in this writ petition filed under Article 226 of the Constitution of India. On the ground that the respondent number 3 who is sought to be transferred is holding a substantive post of engineer. Next paragraph. The Learned Additional Advocate General prays for some time to obtain instructions. Next paragraph. Issue notice returnable in 2 weeks.
My lord may dispose of the matter, my lord, if possible, my lord. Because representation, my lord, you was submit only 10th, my lord. Today we are 16, my lord, Saturday, Sunday. That way, my lord.
You want a disposal?
Better, my lord, it's a transfer posting, my lord.
Representation was filed on 10, your lordship. It's today is
Can we
Today
dispose of the
16.
matter?
16, today is 16. Saturday, Sunday, if you leave, then
Oh, okay.
I am concerned that the
It is
represent-
also submitted that the prayer number 3 in the writ petition is to dispose of the representation, submit representation dated 3/9/2024, submitted by the petitioner
on 10/9, my lord.
on 10/9/2024.
Yes, my lord.
And accordingly, he has submitted that some reasonable time be granted to the authorities to dispose of the said representation submitted on 10/9/2024. Next paragraph. In view of the nature of prayer made in the nature of prayer number 3 made in the writ petition, and considering the submission of the Learned Additional Advocate General for the state, the court is of the considered opinion that the matter can be disposed of at the motion stage without issuance of notice on the respondents by directing the commissioner, no, not comma, within bracket, Urban Affairs, bracket close, comma, Department of Urban Affairs, Government of Arunachal Pradesh, to consider and dispose of the representation dated 3/9/2024 submitted by the petitioner, namely Sri Tara Hachi. Yes. On 10/9/2024. By passing a speaking order. Next paragraph. Seven days time or 10 days? Next, on a query of the court, the learned additional advocate general has submitted that 10 days time would be sufficient for the respondent number 1 to dispose of the representation. Accordingly, it is ordered that the respondent number 1, i.e. the commissioner within bracket urban affairs from government of Arunachal Pradesh, shall dispose of the herein before referred representation of the petitioner within a period of 10 days from the date of submission of a certified copy of the order by the petitioner. Full stop. Next paragraph. The learned additional advocate general may also send the through his assisting counsel may send a downloaded copy of this order to the respondent number 1 to bring the order to the notice of the said authority. Next paragraph. Till an order is passed on the representation dated 3/9/2024 submitted by the petitioner on 10/9/2024 and communicated to the petitioner by at his email address, comma, the impugned transfer order number page 22, number so and so dated 22/3/2023. Sorry, no, mistaken. 3/9/2024 shall remain stayed, public suspended. Next paragraph. As the court has not entered into the merit of the claim of the petitioner, comma. It is needless to say that if the petitioner is still aggrieved, he has a liberty to approach the court again.
Lordship, in the said, I have placed my reliance on the judgment passed by this honorable court, Your Lordship. That observation may be made, Your Lordship.
We are not disposing it of merit.
Lordship.
Therefore, we are not making any observation.
Lordship.
Yes, Mr. Patil.
Well, it is item number 3 and 4 pertains to non-payment of the additional compensation amount. Well, there are series of cases which we have filed, and that has been already transferred to the principal bench.
Okay.
Well, today, simple notice may be issued. We will take further steps at Guwahati. The registry will automatically transfer it. There is already an administrative order from the Honorable Chief Justice. So today.
Okay. Mr. Tony Patil, the counsel for the petitioner has fairly submitted that the issue raised in this writ petition is being taken up for adjudication before the principal seat. Before the division bench or.
I may be directed to take steps. That steps we will, because I'm going day after tomorrow. So
okay. Principal seat. Stop.
Simple notice.
Next paragraph is also submitted that the further steps as required would be taken up before the principal bench.
Yes, please.
A principal seat. Stop.
There we will join along with the already pending cases.
Yes. Mr. Mr. N.
Ratan. N. Ratan.
Then the senior government, you are.
Additional AG.
Additional senior government, okay.
Additional AG.
Additional AG, the state is present for the respondent numbers
3 and 4.
3 and 4. And who is representing NHPC? No one.
No.
No, not yet.
Okay. Next, accordingly, the Learned Council for the petitioner is at liberty to move the appropriate bench in the principal seat for appropriate orders.
But only
Next one.
in other cases, only there was just an observation that pendency of this petition shall not be abated if anything is found.
No, because if it is being taken up by the principal seat, I may not.
Even if without that, the observation also will do.
So the registry shall expeditiously transfer the proceedings to the principal seat.
4 also, no, same. 3 and 4, same.
Same.
Obliged.
May I appeal your lordship? My lord, this matter will be taken up tomorrow, my lord. Here, my senior government advocate is appearing, my lord.
Pardon me?
This matter will be taken up tomorrow, my lord. I've taken consent from the petitioner, my lord.
Can we take it up day after tomorrow?
No, tomorrow, my lord.
Tomorrow.
Yes, okay.
On the prayer made by Ms. T. Wangol and the government advocate, list on, take it tomorrow. Yes.
My lord, on given last opportunity to file an affidavit, they have filed the affidavit today, and just today only I have received the affidavit. So my lord, kindly provide me some time to go through the affidavit, and the matter will be listed on Thursday, this Thursday.
But Miss
J Das, J Das,
J. Das.
on behalf of
Counsel for the
case.
petitioner. And Mr. G. Tarak, Learned Standing Counsel for the RWD. Next one. The Learned Counsel for the petitioner submitted that received a copy of the affidavit in opposition filed by the respondents only today, and she seeks some time to take appropriate steps as she may be so advised. Next, para list on make it Friday.
Friday.
List on give Friday. Friday is 20. Okay.
Okay.
Would approve my execution of work as a subcontractor. And subsequently, the contract have to be terminated for the default of the contractor. Now, it is an admitted fact that as a subcontractor, I have completed according to them more than 26% and all, and I said more than 49% and all I have completed. And then, my lord, since they did not pay, I have approached this court. Initially, this court has ordered for a joint verification of the works that I have done. And after an order was passed as to why the payment cannot be made to the petitioner directly. Come up with any proposition on that, my lord. As many as 12 pleadings are there exchanged between the parties. Appeal matter may be admitted and.
Mr. Katul, on 22 to process the bill. What has happened thereafter?
My lord, in that, my lord, pursuant to that order, my lord, we have filed additional affidavit saying that, my lord, the bill has to be processed through, my lord, as per the original contract agreement made between the, my lord, the parties, by which, my lord, initially, my lord, the bill has to be submitted by the main principal contractor, Balesia, my lord. And the Balesia and once the Balesia, my lord, there is a, my lord, the other formats, which has to be compliant by the contractor, my lord. By virtue of the principal contractor, he has to submit the entire bill so that it can be processed. So therefore, my lord, we have specifically filed a additional affidavit stating that bill.
Mr. Segia is a subcontractor.
My lord.
What happens if the principal contractor does not submit the bill?
My lord, there
He
is
loses his money. You have approved him. That's what Mr. Segia said.
my lord, approve is in respect of only 49% only, my lord. 49%. In that approval also, my lord, the usual procedure, my lord, it has to be routed through the main
No, I
principal.
understand, but let us take a test case where the principal contractor does not want to pay him. Then what happens?
My lord, earlier occasion also, we have, my lord, the process as per the bills received from the principal contractor, my lord. If the dispute is between the principal contractors and the subcontractor, my lord, we are, my lord, not concerned with.
The contractor is a party here.
Yes.
He has appeared.
They had, they have not appeared. In fact, my lord, this contractor is under, my lord, liquidation process. My lord, Bombay, my lord, this liquidation process has been initiated way back in 2020. Still, they have not communicated us, nor they have taken any action. My lord, the defunct, my lord, body, I have spent
But
all
that
my.
changes the situation. If there is a liquidation going on, then it changes the entire situation.
Yes, my lord, this.
Then even
this account would not have been seized, but what I.
But Mr. Sahi, I'm saying, once there is a liquidation proceeding going on, that means IBC.
Yes.
When the matter is subject before the IBC, then even a writ court cannot pass an order.
So it has, my lord, nothing to do with the, my lord, proceeding. My lord, what I wanted to say, my lord, right from the beginning onwards, my lord, the contractor did not, my lord, cooperate with the subcontractor with all his money he has been doing only for the purpose of payment. An SQ account was, my lord, opened, where, my lord, 97% is to be, my lord, to come to the, my lord, subcontractor. 3%, my lord, will go to the, my lord, contractor.
Then you see, then the assumption makes sense. I'll just put a query of the court. Please answer it. You see, what happens is that if there is an agreement by virtue of which the principal contractor will have to raise bill. Correct. Therefore, if you are to receive any payment, it will be through a bill which is raised by the debtor who is before IBC. Now, once IBC takes up the adjudication, then the problem is that they can't do it. You see, there must be a declaration first that this is a work which is done by you, and where they don't have any, we could not have any judgment of, I think, Calcutta High Court. I forgot. Because you have to make a distinction that this amount of money, they will have no claim, because otherwise, when IBC is there, then they take over everything, and the writ court would have no power to an order. There's a Calcutta High Court judgment in such matters. Please try to find out. I read it long back. Not acquainted.
Exactly, this is the situation, my lord, the judgment has to be found out, my lord. Exactly is the situation. Right from the beginning, well, up to 49%, I am to do the work with my own money.
But then, Mr. Khatter, you'll have to take instructions. If the query which I have made to Mr. Segia, if that is right, assuming my query is right, then for him, the principal contractor will make a bill, and whatever bill he makes will go to the IBC. How does he receive a payment? Same question to you in a different form.
At the very beginning, the escrow account has been open and all bill transaction has
No,
made.
please try to understand the query. Whether it is an escrow account or whatever account, once IBC takes over, it has all privacy control all those accounts. Your private agreement to have an escrow genuine receiver of the bill will not get its bill and it goes to the IBC, where the contractors get all the creditors get pro rata payment. That cannot be the intention of the government. If he has done the work and you are aware of it, then his part of the share you must make a device a way to give it to him.
Therefore, in additional affidavit, my lord, it has been clearly specified.
No, we understand that.
My lord.
But does the government want that an undeserving person gets the money? That cannot be the intention of the government. When you approve him, please try to find out a way. And I
Well-
think you also have to amend this prayer to include that insofar as your part is concerned. There's no access with any work done with them. And you will have to write to raise a bill. You have to have a declaratory right.
My lord, admittedly, that part is not.
But that
my lord,
has not
in-
come, my lord, in this case, my lord, because termination is not on the ground that, my lord, my lord, the contractor gone on liquidation or etc. My lord.
Pardon me?
Now, only trust of, my lord, the respondent is that as because the contract clause provides
No, that is. See, you have to get that part.
yes, Lord.
Which is within 26, section 26 of the specific relief act. Whether that power the High Court can exercise and rate, we don't know. But unless that is done, you are at a difficult position where, because if they raise a bill, then the amount goes to them.
But that's what appears to be the intention, whether admittedly I have executed the work with all finance. In fact, they have also directed them to clear my bills. And my lord, their
But you
contract.
can't do it. You see, the IFR was 22. Now, IBC code, I don't remember. But once there is a debt,
Yes,
which
well,
is
that-
to be received by them,
Lord.
then it is go to the IBC.
Yes, that's what, my lord, what, that is the intention of the respondent at the appeal. Go and go somewhere.
They are not saying that is their intention. They say that it's a contract. So that contract, unless ratified within the meaning of section 26 of the specific relief act, can you get a secret?
I'll see to it, my lord, I'll see.
Please examine
And
it
if you don't
because-
know, I'll definitely amendment if you go.
Too much of CPC makes a man. Try to find out. the
Well,
answer with
I'll
them.
come with that.
Please interact with
particular-
them.
My lord, admittedly, all that IBC party is not reflected. no.
Please,
Yes.
because once you say, maybe
My lord.
we can't just. It's only that.
Yes.
So we then the. What do you call? The dues become. What is called charge dues. So it's right that he has.
He even did not go for joint verification or my lord, he did not raise any bills.
It's okay, but
There are department only concerned once they
no,
registered for.
that not- we were told you the reasons.
My lord.
It is conveyed to them.
Yes. I'll come into that is.
No, IBC, matter is pending before IBC for that principal contractor. Have you brought on record in this report?
No, man, no, wait.
It is mainly termination order of contractors. Otherwise, the issue is not because of that proceeding, they cannot pay.
Which is that page, termination order?
134.
74. Which paragraph?
Perhaps G, my lord. Clause Z, clause.
By the way, we have got a order of the order dated 21/10/2022 from the NCLAT. You have a copy of that?
Copy.
Yes, if any attachment is made for that work.
And they are finding a logical similar. Page 135.
No,
Or Lordship may read the last paragraph of
just
page 134.
just a moment. I'm reading it for a different purpose. You see, in a IBC proceeding, the company is required to give the details of the receivables. Now, once they declare this dues to be receivable before the IBC,
Yes.
then you will be in difficulty. That's why I'm trying to understand only that part.
Yes.
Because then you would be mandatorily required to get a declaration that that part of the work is done by you and not by them. That's the point. Oh, no, it's not there.
I'll similar, adjourn.
You see, the second part of it would be that once this work is declared before the IBC, then the only way you can realize.
Simply adjourn for 2 weeks and
Heard Mr. PJ Sekia, learned senior counsel, assisted by Mr. KJ Sekia, counsel for the petitioner, the petitioners, as well as Mr. M. Kato, learned CGC, appearing for the Union of India. You are representing whom?
Question number 1 to 5, perhaps.
All the respondents.
1 to 5.
Representing
1 to
respondent
4.
numbers 1 to 5.
1 to 4.
1 to 4.
1 to 4.
My
Okay.
lord.
1 to 4. Stop. The learned senior counsel for the petitioners. Preference was granted 2 weeks time to address the court. Take 2 weeks time to obtain updated instructions. Matter stands adjourned today, list after 2 weeks.
My lord, my appearance may be marked, my lord, for respondent number 7, the bank, pro forma respondent, my lord.
Oh, okay. Mr.
A. Sandilya, my lord, for the respondent number 7.
Sandilya, learned counsel appears for respondent number 7. Okay.
Well, the interim order passed and you make it.
Interim order passed today stands extended till the next date of the stay. You're also there.
I'm for respondent number 5.
P. Pangul and government advocate appearing for respondent number
5.
5.
Well, this case, my instruction long like they have already withdrawn the EMI.
Pardon me?
They have already withdrawn the EMI. Unless money
Unless
deposit.
money.
Yes.
The petition is withdrawn.
Oh, already withdrawn.
Yes.
Your Lordship, I'm appearing on behalf of Mr. Tita. Matter, Your Lordship.
Hardness.
N Hondik. N Hondik.
N.
Hondik.
How do I spell it?
Huh?
Spelling?
HONDIQUE.
Oh, Hendik. Okay.
Yes.
Learned counsel for the. You're not on record. Are you on record?
Yes,
Are you on record?
Your Lordship, my name is not there in Wakalat Nama. I'm appearing
on behalf of Mr.
Titaba.
Taba, TBA, learned counsel for the petitioner. Mr. G. Tarak.
1 to 5.
Learned standing counsel for RWD representing respondent numbers.
1 to 5.
1, I think, is Chief Secretary. Numbers 2
to
3,
5.
2 to 5. Submits that as per instructions received by him, the petitioner has withdrawn the earnest money deposited. Yes, P. Pangul, and government advocate appears for respondent number 1.
Respondent number 6.
You are
6.
6. Your name?
And Ngongya on behalf of Titagum.
And
Ngongya.
learned counsel appearing on behalf of
Titagum. Titagum.
T. Tabung.
Tabatagum.
Tabat Tabung, learned counsel for respondent number T. Tagum. Okay, learned counsel for appearing on behalf of Mr. T. Tagum, counsel for respondent number 6. Next one. On instructions received from the petitioner, the learned counsel for the petitioner seeks to withdraw this petition. Next for prayer is allowed. The matter stands dismissed on withdrawal.
Much obliged, Your Lordship.
My lord, item 10 is show moto contempt, directing us to publish the notify the RR for Director Tourism, my lord. That has been done, my lord.
Has been done.
Yes, we have notified on.
Yes, we close this matter then. Mr.
My lord, I'm representing on the behalf,
Your name.
contacting council
Your name.
Tony Gami.
Council, appearing on behalf of Mr. A. Talon, counsel for the petitioner. Next, Mr. N. Ratan, the Additional Advocate General for the state, has referred to the judgment and order dated 13/2/2002, passed in WPC 981 AP of 2001, wherein direction was issued to the state the recruitment regulation to the service conditions of the Department of Tourism, including the an appointment to the post of director within bracket tourism or equivalent post. It is submitted that due to non-compliance of the said order, suit or contempt case was registered, and notice was issued to the contemners by order dated 27/6/2024. Next, brother. The learned Additional Advocate General has produced a copy of the Arunachal Pradesh Extraordinary, published on 13/9/2024, containing notification numbers also dated 13/9/2024, thereby framing and notifying the recruitment rules for the posts within bracket post group A, gazetted A, recruitment rules 2024. Yeah. Full stop. Next one. Accordingly, the learned counsel for the order dated 27/6/2024, passed by this court in WPC 428 AP of 2023. That order was passed to register a contempt. So only on registration of contempt, the matter was listed before the court on 28/6/2024, on which date notice in the contempt petition was, the suit of contempt petition was issued. Next one. On a query of the court, the learned counsel for the petitioner, upon instructions, has submitted that on application of the rules, comma. The order of the court has been complied with. Next one. In view of the said submission, comma, this contempt petition is closed on satisfaction. Next one. The copy of notification dated 13/9/2024 is made a part of the court.
My lord, writ petition, my lord, has become infructuous, my lord, because the writ petitioner is a joint director. He wanted promotion, but he is now not eligible as per the recruitment rule.
As for the, yes,
Yes, ma'am.
what is your submission?
My lord, I am not well versed about the fact of the case.
You're not well versed.
Yes, my lord.
One prayer was for, even he had read the recruitment rule.
Next para. The learned additional advocate general has submitted that the prayer in this repetition one of the prayer made in the repetition is to direct the respondent authorities to promote the petitioner to the director within bracket tourism. It is submitted that as per the recruitment rules for the post of director so and so copy, 2024, the petitioner is not eligible, and accordingly it is submitted that the matter has become infructuous. The learned counsel for the petitioner takes some time to obtain instructions. Next list after 2 weeks, on date to be fixed by the office.
Always.
Yes.
Please. Be a part of the senior counsel. May I may be given some more time to go through.
I'm
the
sorry,
report.
my lord. I will tell you also why I have an objection. File an application have served long back. In this case, there is an order which has been passed by this court saying that ending before a division bench, 41 of 2021. This appeal is pending, and now when the matter was taken by the learned single judge, where writ petition Union of India 374 of 2022. In that case, they said a similar matter is pending before the division bench. That is why this matter should not be after the verdict of the learned division bench, it should be taken up. So now, my lord, if your lordship looks into it, the entire matter of this, why we are saying it is not a similar case. Why we are saying it is not a similar case, we have filed an IA for recalling of the order, and my learned friend has filed a reply in that case. Kindly look into an application.
You are seeking modification.
We are seeking recalling of the order.
Which order?
At my IA 48 of 2024. 48 of 2024.
Yes. Which order?
Order dated, my lord, the is of 17/5/2023, my lord.
Page?
Which is 20, it starts my 48 of 2024.
Page 20.
Yes, at
Yes.
page 20. And see at page 21. Lordship got it? My IA 48.
Yes, yes.
If you see at the order starts page 18 and it starts from page 21. It may be mentioned, Lordship got it? It may mention that in respect of an identical matter pertaining to another an award dated so and so, passed by DC so and so, and as the same was not honored by releasing the amount, the land affected person has instituted two numbers of writ petition which were allowed by judgment dated 7/11. The said judgment was a subject matter of writ appeal number so and so, which was dismissed on 7/10/2021, whereby the appellants were given liberty to institute a reference under section 64 or an appeal under section 74 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act. Thereafter, in that case, the Land Acquisition Appeal, LA Appeal number 2 of 21 was instituted. However, the said appeal was dismissed by this court by the order dated 10/12/2021. Thereafter, a fresh writ petition was instituted by the Union of India, being so and so, which were however dismissed by this court by judgment order dated so and so. Cato learned so and so, an appeal has been preferred against the said judgment, being WA 41 of 2000. He further submits the interim has been passed in the same writ appeal. The present petition is almost of the same background into another plot of land. Since the court has been apprised, critical issue pertaining to another plot of land is a subject matter before the honorable, which is pending consideration in the interest of justice. Present matter will be adjourned for a period of 2 facilitate the party to place before this court the outcome of the writ appeal. The parties are liberty and the writ appeal is disposed of, mention it before so and so.
Yes.
Now, our whole case is that this writ appeal, my lord, the date of acquisition is different. The date of acquisition is different. The difference in those cases, in my case, is that, my lord, when the award was passed in my favor, approval was granted by them. Land certificate was issued by the authority, by the deputy commissioner. All these cases which was for appellate court, these were not there. Completely on a different footing altogether. Maybe, my lord, the army, before the land was before the Assam rights, over by the IDBB. But now, thereafter, when the award was passed, or there was given, in that case, willingness certificate was not there. Completely on a different subject. Maybe on a different. Date is different. Notification, my notification under 40. Notification under 11. So there is difference of 40 and 11. So what I pray, not trouble your lordship to take today itself. What my say is that, my lord, let it be taken up separately in this case, my lord. Let it be no with those bearing with those cases.
The difference of notification and all, whatever.
Yes, yes, I take your lordship. Kindly look into the notification. No. My lord, we kindly see, he is moved by me, but 374.
The objection
is the
objection to IA is also.
See the objection, my lord, the affidavit filed by petition. Date 21st of August 2019. There is no date of notification.
Yes.
Now, if you see the section urgency clause under section 41 of the Fair Compensation Transparency of Land Acquisition.
Yes.
Now, see kindly, my lord, serial number 1, Dibang Valley, Circus is ethylene. Name of the area is ethylene. Location is ethylene.
Yes,
Lord,
location.
got it?
Yes.
Now, my lord will see at page 54. Kindly note down one thing, my lord, by the side. My lord, the other case, 41, your lordship will kindly note down one thing. It is under section 11. Date of notification.
Did I hear this matter earlier? This village Italian
I'm
comes to
sorry.
my mind.
Ah, yes.
Did I?
No,
did
your
I-
lordship division bench court, your lordship was a part of it and Honorable Justice Nair was a part of it.
Okay, so this village.
So, this particular day mentioned in one of the paragraph, but this was never in a separate writ
Okay,
proceeding.
no, this village Italian.
Yeah,
Yes.
Italian, because what they have done, 5-6 places, it was taken off by the ITP, but this was on a different notification altogether in a context.
Okay.
Now, my lord will kindly see, only note down one thing. In that case, the acquisition date is notification is 10th of May 2018. 10th of May 2018. And one second, but this is 1 second. No. This is 24th of April 2018.
24.
The
April.
notification, 24th of April 2018. And the clause which they have invoked is under section 11. That case, which you under section 11.
You know which act?
I am right. Right.
Okay.
Both is under Law Act. One is 40 and that was under 11.
Yes.
Now, my lord, in the present case, 54, there was at page 50, some amounts passed, 50, which they calculate about 85 lakhs.
Yes.
Subsequently, at page 63, it is fine 85 lakhs. Your lordship will find 85 lakhs. Page 55 is a specification of the landowners and compensation due.
So now I recollect. In
Yes.
that case which I had, the argument of Mr. Kato was that the land of the community was involved and the compensation was being claimed by Rohit Mele, individual.
Exactly.
Yes.
Correct?
Yes, ma'am.
Okay.
An early round of the petition, my lord.
No, I have
enclosed
mentioned
the-
everything. I have
Ah.
mentioned here.
No, not that. I'm just
Yes,
thinking
yes.
why I am recollecting it.
Yes.
That is the background.
Because though I was not in 41, I got the appeal and I have looked into it. What was the case in 40? Because I have to look into to find a difference between this case and that case, my lord.
I get it. Huh.
Yes.
Yes.
9th of January at page 63.
63.
At 63, 2015. The calculation which they have arrived, they said that 85 lakhs was not the correct calculation. Multiplication factor has to be looked into it. So at page 63, kindly see, my lord. the base rate of multiplication factor of the market value under so and so for the purpose of determination of compensation in respect of rural and urban areas, factor which by the market value is to be multiplied in case of urban areas, factor which the market value is to be multiplied in rural areas. So ultimately, it was made and the amount was changed, had changed to 83 lakhs, which your lordship will find at page 68. 68. This is the fresh page 68, 1st of June 2020, 83 lakhs so and so. After looking into the provision of this act and the multiplication factor was taken into account, and the conclusion of the Deputy Commissioner in fixing of the award was 83 lakhs. And that was approved. Approval was granted. Now, approval which was granted, that is the award, but before that, at page 60 confirmation, at page 65,
55,
65,
65.
65.
Yes.
With reference to your letter dated, so I'm trying to convey the approval of the government for award of compensation under section 23 at Ethylene Village under so and so, so and so. At page 65. Now at page 66. After the
Just a moment.
award is actually of 1st of June. But at page 66, 2nd of June, it should be thereafter. 2nd of June.
This is just a moment. 65 we are showing for purpose of
For
approval.
approval.
I do not follow. What is page 66?
66 is the where I shown at page 68. Your lordship will note it down. Page 68 is 1st of June 2020. That is the award. After calculating the figure, which is arrived at 83 lakhs.
Yes.
It was initially 85 lakh, but they said it has to be calculated. And ultimate, that's an award, 1st of June 2020 at page 68.
Yes.
If your lordship kindly see at page 66. Yes. 66, 2nd of June 2020, it should be after that. This was before that actually. Well, that was 1st of June 2020. But this is at page 62nd of June. It should be after that actually. This document should have been annexed after 1st of June 2020. Which was earlier, because 2nd of June 2020 is an intimation to the commandant by the government. Now, yes, this letter is important, my lord. Kindly look into it. This letter. This spot joint verification was conducted with the board consisting of members mentioned in a joint verification report dated so and so, as per the order letter dated so and so. Whereas, after the spot verification, along with the ITPP representative, land acquisition process was initiated, and the process now stands completed with the approval of draft award by state government. Whereas, as per the queries made by your good office, wide letter dated so and so, the serial wise reply to the queries are as follows. 1. With regard to the first query, spot joint verification report is hereby enclosed for your kind perusal. 2. With regard to the second query, no values of trees and plants were estimated for valuation of compensation. And regarding the ownership of the building, you may kindly refer to the joint verification report dated above, wherein it was accepted by the board members. Now, 3 is important. With regard to the third query, with regard to the third query, the land ownership certificate is hereby enclosed for your perusal. Now, for pausing for a moment, on those cases, my lord, 41, I have looked into those cases 41, which was before division. These ownership certificate were never. That is why your lordship recollect said that it should be looked into by the state government to determine whether it is a community land or it is a government land. Now, that was here, it was looked into it. Their person was present at that relevant time, and they asked for whether there is an ownership certificate in favor of this particular person, or now this certificate was given to them. Therefore, my lord will kindly say last, therefore it is direct, matter shall be forwarded to higher authority, compensation amount shall be deposited in earliest, so and so and so. Now, my lord, after that, they were relieved. So they have written to the Deputy Commissioner that this matter should be sent for reference at page 692. There's a type copy which starts from 76. 92, a reference under 64. Now, if your lordship kindly see the prayer, reference starter 92. The command has a type copy. And application 64. Lordship got it? Addressing to the Deputy Commissioner. Yes. See the prayer, my lord, at page 107. 107. at 107, the prayer. A prayer, it is therefore humbly requested to kindly admit this application so and so and be pleased to cancel, revoke the notification published and award dated 17/12/2019, convert the 3 acres so and so, please to issue formal allotment order in favor and also fix the land rate as land by government of in respect of land required for so and so. And also please to treat aforesaid land as a demand note, please to accept the otherwise payment of land revenue as sanctioned by and do the needful action to process the issue of formal allotment in our favor and so and so. Now, this matter was adjudicated by the reference court. Now, this deputy commissioner has sent to the district court. My lord will kindly see at page 125. Page 125. Page 125. It is sent by the DC to the presiding officer. Reference. Lordships kindly look into it. Second paragraph is the amount of compensation and the objection by the ITP and the quantum they were asking is ₹10 per square meter for regulation of land presently occupied by them at page 125. Lordship got it? Now see kindly last, the primary objection regard to compensation for structure present in the land currently occupied. This structure handed over. Such ITB has no document. Hence ITB by Rase and has such ITPP has no documents regarding them. As award has already been passed and approved by the government, objected to, the same is being referred to the Honorable Court for further necessary action. So this was sent to the reference court and the reference court heard the matter at page 127. And at page 133 by the reference court on merit, it was decided by the reference court without going into the maintainability of the case. At page 133, the Lordship looks at paragraph 14. My lord, if your lordship find at 130, please see at 130 finding. 130 finding of the reference court at para 10. Para 10. Accordingly, this court without discussing the technical issue raised by the counsel for respond number 2. Technical issue means, my lord, whether the reference is maintainable or not. Court said without raising all those dispute, has decided to hear the counsel for parties rather on merit of the case. Thus, after hearing the counsel of party, this court has come to note that the said land in question occurred as per section 41 of the said act. And now the said land as per submission of the counsel of the applicant is in possession of the applicant. This court, therefore, opines that the said land was urgently in need of the applicant for his use because the said land has been acquired under section 41 of the Lara Act. Thus, this court is of the opinion that the applicant for whose interest the land has been urgently acquired should have been more vigilant and careful during the time of measurement of the land, fixation of the component amount. This is because the applicant is made one of the said board members who verified and calculated total area for which the compensation amount was to be paid to respondent number 1. The present applicant is in fact made as one of the board members to protect his interests. Thus now after having taken the land in possession, Lordship got it, man. The response number 2, he instead of delaying the payment of the compensation amount should have paid the said compensation amount of 83 lakhs so and so respondent without any delay. Now, my lord, your lordship looks into at page 133. At page 133. Only showing before this court, because these are not to be adjudicated, only showing how it is different with that. At page 133, with this observation, the court is of the opinion that this is a fit case which can be disposed of at this stage of first hearing, according below order is passed. The applicant independent represented by so and so shall make the payment of compensation amount to so and so to the respondent so and so. Applicant represented by commonwealth shall pay the awarded amount to respondent within 2 months from the date of disorder. So and so shall make a payment of 6% interest, so and so. So now against that, a decree was prepared at page 134. 134. At 134.
Has this reference judgment is held? No.
This reference judgment was put to challenge before before this court by LA. Number 1, this was taken into consideration on merit. Court said that no, father has to be heard. Some issues has to be decided. Then it was set aside, and this was sent again to the reference court. Reference court heard the matter afresh, and maintainability also was raised by the council. It is not maintainable because there is an embargo under 95(2), because they are only the requiring authority. Requiring authority is embargo under 95(2). I have seen that some of those cases, that was a point where also were argued 95(2) whether the embargo or not, because there is a clear-cut embargo. So on this ground itself, entire judgment, I have annexed all this, citing the judgment of the Supreme Court, how there is an embargo, because they choose to go before the reference court, knowing very well. They went, merit was decided. Thereafter, this court said father has to be discussed by the reference court, it was sent back. Now, this time when it was sent back, the point of maintainability was also raised. On the very, your lordship has looked into reference court, will not go into technicality, we'll go into merit of the case. So technically part, even though we raised at the first instance, it was not, let us go into merit of the case. So here difference, there is no decree in those cases. Decree, reference, all these were not there. Now, my lord will kindly see, very interesting, decree was prepared at page 135. 135. The decree which was prepared. They prepared at page 134. 135, this was sent by Deputy Commissioner to the commanders. Kindly see amount relation reference to your letter, permanent acquisition of land. Therefore, the total realized amount is so and so, only require deposit said amount, so disbursement of the amount. Now, my lord, this letter will kindly taken to note by this court as page 136. Page 136. This is 2021. Kindly note it. That now they write to the DC. Kindly see, my lord. Refer to your letter regarding subject. It is intimated that this officer already forwarded the matter to our higher headquarters. Our headquarters has sought some clarification regarding calculation of compensation amount, requested to get it reviewed on following points. Now, it is not a case. They have said no. This person is not entitled to get it. What I am saying, Your Lordship, this is what they have never said. It has been said for the higher, and higher authority has approved it by letter. Kindly see now, number 1, valuation of building and other asset seems to be on higher side. In this regard, you are requested to provide copy of estimate calculation sheet showing valuation of the building, other asset along with the basis of valuation like so and so. It is this building have been built before the Assam Rifle took possession of the land in the year 1959. Further, out of two buildings, one building is temporary, other is permanent. Since these buildings are very old and ITB has taken over this building in charge from Assam Rifle in the year 2005, hence in that case, valuation of this building is required to be calculated on depreciation value of the building. Solution of 100% imposed on total cost of land building, whereas it should only be imposed on land cost. You are therefore requested to look into matter and please get it reviewed considering the above point so that the payment of compensation can be made according to the earliest after obtaining express sanction of the competent authority. So all those cases which the adjudication is on a different context altogether. Because here your lordship, lot of things has happened. Now, now, my lord will kindly see, reply immediately was given by the Deputy Commissioner at page 137. 137 to the command. 137. After this, after 136.
Yes.
137. Submission of clarification in regard to payment of compensation. Number one, valuation of property may kindly be seen. Number two, valuation of building has been awarded as per the estimates submitted by the competent engineering department, which may kindly be seen in enclosed annexure so and so. Further, the forwarded amount, award amount into 6% interest on amount or earlier, even letter number has been followed as per the court judgment. Regarding the payment of Solicium, 100% has been followed as per Lara Act, first schedule under section 30 of the Act, which may be seen highlighted in Annexure D. So thereafter, the execution, my lord, at page we've started, and the amount, decretal amount was deposited in the High Courts. Now, if your lordship looks into the deposited in the High Court land ownership certificate, and at page 148, my lord, 147, your lordship will kindly note down the landowner certificate at page 147.
Page?
And one second, my lord, one second. The order of the court is page 138. First, lordship looks into 138. 138. At page 1, at 138, 11/10/2021. In money execution case. Lordship will kindly see in money execution 3 so and so, Millet versus Union of India. We gone for money execution. At page 140, kindly see 140, the last paragraph. After having perused the said letters written by judgment debtor to his higher authority after hearing the judgment debtor and his counsel, it is observed the judgment debtor is taking step to get the complaint amount released so that the same can be deposited in the Honorable High Court where the appeal is pending. Thus, the court is opinion the Commandant ITP who represent the Union of India should be given 1 month time as prayed for, because in the meantime, against the reference, they went before the High Court, LA. Now, lordship will kindly see at page 148. 147. Kindly see 147. Please note down 147. This is a landowner certificate where you don't find in those cases. This is landowner certificate, 22nd of June 2020. This is by Deputy Commissioner, Dibang Valley. Lordship got it? Now, deposited in the High Court at page 148. Now, at 150, that is the memorandum by the Union of India by them, at page where sanction is granted, which is type copy, your lordship will kindly see at 153, which is not very distinct at 150, not legible. So there is a type at 153.
Page?
At 153 is a type copy, 153. By the Director General ITB Force. Lordship got it?
What is
30,
this?
31/3/2022.
What is this?
This is, my lord, where they have approval and sanction was granted by them in pursuance to the court's order at page 155. See at page 153 and 155 at paragraph 6. However, approval, sanction of 92,56,000 of decreed amount in connection with acquisition regularization of so and so at an location in so and so has been accorded by Ministry of Higher Authorities by letter dated so and so dated 2/11/2021. Ministry has also accorded sanction granted. Now, at 157, one 157 is the order passed by the against the reference court order. Appeal was preferred 1 of 2021 by Union of India. At page 172.
One.
172 is the operative portion of the order. At page para 30. Accordingly, the impugned judgment order passed by learned district judge stands set aside. Matter is remanded back to district judge to frame appropriate issue on the point that has been raised by the appellant under section 64 of the said act, and then to decide the same afresh after affording opportunity of being heard and to adduce evidence to the concerned party. In the result, appeal is allowed to the extent indicated above as the matter is concerned with national security. Learned court below stand proceed to hear the matter on urgent basis and dispose the matter with a period of 3 months from date of receipt judgment. Accordingly, at page 173, the matter was heard in detail by the reference court at page 173 on 27/7/2022. And the maintainability point 64 reference, whether it is maintainable, because that was indicated by the learned single judge. So that was taken by the court. And ultimately, if your lordship looks into it, the judgment start from 173 to 189. Now kindly see the operative portion 189. At 189. At page 22, para 22, page 189. I have heard the rival contention learned counsel appearing for the parties. The law is well settled that a pure question of law can be considered as a preliminary issue. And on agreement of the party, this court has decided the preliminary reference under section 64, because that was indicated by learned single judge. 64 is maintainable on behalf of recurrent body due to the legal embargo imposed by proviso to section 95(2). In this case, Deputy Commissioner submitted reference on the request of the commandant for whom the land was acquired. Therefore, this reference case is not maintainable. Mentioned above, according to present case is liable to be dismissed on the ground of lack of jurisdiction of this court. So this is the case. Now, my lord, your lordship just recollect that decretal amount was deposited before the High Court. Once it was set aside by this court, then they made an application to refund the amount that we should, and accordingly, it was again day when it has gone back to them. That the amount of 92 lakhs which they passed by way of a decree, and they deposited in the High Court because reference court, because they filed an appeal for this court which was pending. So that is why they deposited here. Now, when the matter was set aside, then automatically they made an application, they should go back to them, and accordingly it has gone back to them. Reference court has decided, my lord, only because that was the first issue. Court said, look into whether 64 is maintainable or not. Now that was decided by the reference court that it is not maintainable. Now, against that, they filed a present writ petition 374. Now, what they are saying, entire that particular award should go. Entire award should go, and they said there are similar matters which is pending. So please do not. Notification is different. His notification is different. This notification is under 40. That is under 11. No, 11 there is a procedure. They have to follow that procedure, and their notices is required. Gazette notification. All the 40 there is no question. Well, all these cases, well, I am dealing now. What I found that 40, which is parameter of 17 of the earlier act, this is for the urgent basis it is required. There is no question of any notice to be given. Immediately it is taken, and the legislature felt, if your lordship looks into 43, kindly see 43 of the act. Oh, kindly see, my lord, 40 and 11, there is a difference. That's why I'm saying. See 40, my lord, which is parameter of the old act, 17. See 40, my lord. Special powers in case of urgency to acquire land in certain case. In case of urgency, whenever the appropriate government so directs. Now, my lord, your lordship looks into it. There is an approval which has been granted. Approval which has been granted by them, and they have taken over. The collector do no such award has been made. Here award has been made. May only expect 30 days from the publication notice mentioned in section 21. Take possession of any land needed for public purpose, and such land shall thereafter vest absolutely government free from all encumbrances. Now, if you see at 3, my lord, here the possession was taken long back. See at page 3, 41.3. Before taking possession of any land under subsection 1 or section 2, collector said tender payment of 8% of the compensation as estimated by him to the person interested entitled to thereto. 80% has to be paid. But here a difference in this case, because it was with them. Now there is a sanction approval which is granted by them. Now your lordship has seen one letter. They are not saying. Now my lord, let me put in this way. The matter has gone to such an extent, if they really don't want this land, that's I got my instruction, my lord, from my client. That's the instruction from my client. If they really don't want the land, let them revert the land back to us. We have spent a lot of money in the litigation for last 2-3 years. And my client instruction yesterday was that, my lord, we will not fight this case, let them return the land back to us. Let them return, because they are, for this, your lordship has seen that there is a sanction, approval granted. There is a letter which indicates that your calculation is higher. They never said that this particular under 40, this should be set aside. How they have issued this 40? So my prayer before your lordship will not, your lordship will just detect this, but this case is not similar to that case. And your lordship will hear it. Lordship will hear it whenever your lordship, my lordship can hear it, this matter. Lot of difference with that case. Only naming that army has taken Assam Rifle, it was 1959, and 2005 it was taken by ITB. So it is identical. How it can be identical?
Just come back to that The issue of maintainability, section 95.
95(2)
How was it dealt by the district judge?
dealt by district judge by the reference code.
Reference code.
Yes, yes, of course. My lord will kindly look into at page 173. It start from 173.
Okay. Specific finding on this 95.
173. It start from 173.
Yes, so the relevant finding of
Oh, yes, sir.
section.
My lord, at page 178, paragraph 9. Be that as the core issue in this case is whether this court has jurisdiction. Lord, you got it?
Findings of
At
the
page 64, section 64, kindly see. Reference to authorities. See. 64.
I have seen that.
Yes.
No such local authority or regulation.
Person interested has been defined in the section 310. Person interested means what? A person interested. 10. It starts from section 3. Section 3 is a definition. See if 3 W after W, V, W, and not Z. I think is X. It's an X. Sorry, X. WX.
X.
Person interested means all person claiming an interest in the compensation to be made on the account of the acquisition of land under this act. The scheduled tribes and other traditional so and so dwellers who have lost any forest rights recognized by scheduled tribe. A person interested in easement affecting the land, person having tenancy right under relevant state laws, including so and so, any person whose primary source of livelihood likely to be adversely affected. Prescribed means prescribed by rule under this act. Project is equal. Now, what is requiring body? It has been defined ZB. Requiring body means company, a body, corporate, an institution, or any other organization or person from whom land is to be acquired. Lordship will kindly say requiring body means a company, a body, corporate, an institution, or any other organization or person from whom land is to be acquired by the appropriate government and includes the appropriate government. If the acquisition of land is for such government, either for his own use or for subsequent transfer of such land is for public purpose to a company, body, corporate, an institution, or any other organization as may be under lease, license, or through any other mode of transfer of land. Okay. So now this has been discussed by the reference code from page 178, para 9. So anyhow, my lord, this is why the court said that they are not the person interested. My lord, my case is that it is completely on a different footing altogether. Maybe it is the Assam Rifles or ITB, but ultimately ownership right by a certificate, which has to be cancelled by the appropriate deputy commissioner. They doesn't have any right to say over that my ownership right. That has been determined by giving an ownership right to me by a certificate. All those cases, my lord, which I have gone through, there was lacuna in those cases. I don't know, my lord, I have found this was completely on a different track altogether. So my submission before lordship is that should be separately, it should be treated. That your lordship will decide separately.
My lord, my submission would be, my lord, almost learned senior counsel has, my lord, the touched the, my lord, the merit of the case, my lord. That is the whole, my lord, case. My lord, quite apart from that, my lord, in response to, my lord, the IA, we have filed, my lord, the affidavit in opposition, wherein we vehemently objecting, my lord, the separations of this case with the two readable, my lord. My lord, more precisely, if, my lord, they can peruse the, my lord, the writ petitions filed by us. My lord, before coming to that, my lord, may I take your lordships to same 2013 Act, madam, section 10, 100, my lord. 100, 100.
Page?
Yes, page number, my lord.
Section?
Section 10, 100, my lord.
100.
My lord. 100. The change of ownership without permissions to be allowed. No change of ownership without permissions to be allowed. No change of ownership without the specifics, the permissions from the appropriate government shall be allowed. My lord. Precisely what we are contending is he is different persons in response to the earlier round of writ petitions, my lord. The earlier round of writ petitions, my lord, we have enclosed a copy of the order passed by the Honorable Court at page number, my lord, 101, my lord.
Page?
Our writ petition, my lord.
101.
101. My lord, he is the, my lord, the first person, original owner, my lord. It is in respect of, my lord, the writ petition number 78 AP 2017, my lord. This is the first round of writ petitions wherein the original owner, Ngashi Mena, he, my lord, moved this honorable court by way of these writ petitions. And, my lord, this honorable court, please enough to dispose of the dispose of these writ petitions with the specific directions to the deputy commissioner. My lord, page number 104, madam, of same order passed by this honorable court. My lord, piece of land has been, my lord, the location of the area has been given at page number 102, my lord. Third paragraph. Fourth paragraph, sorry. In the case of the petitioner is the present resident of the Malini and under Italian circle under the Dibang Valley districts and the community under the landman. I'll skip this part. There is no dispute, madam. Now, what are the specific direction given by this honorable court is at page number, my lord, 104, madam. Last one. In view of the matter, the deputy commissionership requires, I'm sorry, my lord, I'll skip first one, my lord, middle one. In such view of the matter, this writ petition is disposed of with the directions that the deputy commissioner and any Dibang Valley would cause an inquiry and a certain as to whether the land in the question involved in this writ petition is a community land of the writ petitioner or it is a government land. In causing the inquiry, the deputy commissioner would also consult
the land revenue record pertaining to the land from prior to 1955. It is stated that the earlier this plot of land was a part of the erstwhile Lohit district, and after bifurcation, it is part of the Lower Dibang Valley district. In such view of the matter, the deputy commissioner, if he requires, may also requisitions the land record that may be available in the office of the deputy commissioner Lohit district to arrive at a proper. Well, I am reading page number 104, madam.
Yes, please continue.
Well,
I am getting it.
well,
Please continue. I am
Yes.
getting it. I'm only doing multitasking. I'm hearing you.
Well, they will give the writ petitioner or his representatives an appropriate opportunity of the hearing orders to represent his case. And this land is a community land of the writ petitioner. While giving the opportunity, the deputy commissioner would also allow the writ petitioner to provide any evidence and the material that he desires to produce in order to establish his claims that the land is a community land of the petitioner. They proceed, and I'll skip this part. Now, my lord, in view of this order, my lord, there is no inquiry, nothing, my lord. This is the first round of writ petitions wherein direction was given, my lord, without causing any inquiry, my lord. How no, my lord, this is the entire challenge of our writ petitions, that the notification as well as the award was passed by the learned deputy commissioner, my lord.
Yes.
There must be, my lord, the inquiry report on the part of the deputy commissioner by virtue of the district administration and the land acquisition authority. Nothing has been done, my lord, as of now, my lord. In view of the same writ petition, in particularly, my lord, Gita Mehu case, my lord, it is also in page number 87, my lord, writ petition number 11 of 2017. In Gita Mehu case, my lord, inquiry was closed and deputy commissioner held that this piece of land belongs to the government land. And it is also under challenge, and the same is pending before this honorable court. And my lord,
We'll continue at 2.
my lord.
In the meantime, when we reassemble again, please tell us the objection raised first in point of time with regard to the ownership. When was it raised first by the Union of India?
My lord, it has not yet been identified, and the ownership is not decided.
No. We're not asking that question. My question is, what is the first? When was it first in point of time that the question of ownership of the land was raised by the Union of India? The dispute with regard to ownership of the land in Italian was raised by the Union of India.
Right.
What is the first in point of time? At which point of time first this issue was raised?
I'll check it. Therefore, my lord, at the very beginning, my lord, I sought for the adjournment because my lord, some records are not available.
Yes, Sanava.
My lord, this today's item number 14 to 17. My lord, in this matter, my lord, I've been asked by the learned advocate general, my lord, since he'll be appearing in this matter. My lord, can the matter fixed next week, my lord? Item number 14 to
14 to 17.
Yes, my lord. Subject to convenient, my friend, my lord. 14 to 17, man. It's all analogous matter, man.
We are otherwise agreeable on a date on 30th, 30th of this month, Monday.
30.
I'll convey, yes.
No, don't convey. You take his consent and then tell us at 2 o'clock.
Malo, he said next week, Malo. So it will just.
No, that's right. Have it because it also comes from.
Malo, as per his text message, Malo, right now he must be in the abroad, Malo.
Pardon me?
Right now he must be in the abroad, Malo. Yes, Malo.
Let it come on.
Let it come on 30, Malo. It's a Monday, Malo.
30. Okay.
30.
As the senior counsel for the petitioner is present, along with his instructing counsel is present. Mr. R.S. Nagam, then additional advocate general. Assisted by Mr. Dipangu, then submits that he has instructed the advocate general to argue the matter. Full stop. Accordingly, he prays that the matter be listed next week. Next week. The learned senior counsel for the petition has submitted that the respond 30/9/2024. Stop. Praise out list on 30/9/2024.
Well, in all these repetitions, there are interim orders which are operative till today. That may be extended till the next day.
Interim order last addressed and it's extended till the next date of listing. My lord, I am appearing for item number 16, my lord. On same similar matters. You are the petitioner. I am the petitioner.
In 16, he is petitioner.
16, he then Mr. Nikki Sahib, counsel.
Deeply obliged.
Okay, okay, thank you. Date of ownership এটা raise করলে for the first time. So sorry. Your petition. Respect of IA. Our IA affidavit has been filed by the government. If your lordship kindly see their affidavit, because ultimately they are the requiring authority. Their affidavit at page para 6, affidavit filed by the state, by the Department of Land Management.
In IA.
IA 48, they filed an affidavit. Counter affidavit filed on behalf of respondent number 2. What's it got it?
In IA 48, there is an affidavit in opposition of respondent number 1, 2, and 3. 1, 2, 3.
They have filed 1, 2, 3. And 1, 2, and against our IA, the state has filed a counter affidavit, Secretary Land Management, in 48. Recalling of the order was 48, with a registered IA 48.
It's not here.
Counter affidavit, it is here too. This is a counter affidavit. It has been filed. On April 2000. क्या हुआ? But we have received that, that's why. It appeared filing 3rd of April 2024.
It's not.
Yes. Okay. Okay.
Yes, what is the point you are trying to make?
No, they are saying in their affidavit, which we received, they're saying it is not identical. 41 is not identical because notification is separate. They have taken this. No, just I'm placing it. They said it is all separate notification, person is different. Only I was just, your lordship was asking him about when you raise the point of ownership. So I thought that this is only a requiring authority. They are not the authority. If the land belongs to the state. Now suppose your lordship dealt so many cases.
This is one thing.
No, that is true. I was also looking through it. Mila? I think it is.
Okay, we got it. It's in a different
Yes.
file. Okay, that is the only point here.
That's kindly see at 6, para 6.
Can we take your word for it?
Para 6, they are saying no, no. And what I thought that regarding your lordship wanted to know when they have raised this particular point, ownership point, when they have raised it. Even for an argument's sake, my lord, what is their authority to raise a ownership certificate?
No, that's separate.
No, that's what. My lord, a sale deed has been executed. Fraudulently, a sale deed has been executed in my favor. Ultimately, a competent court has to cancel it. They are the only authority who can cancel it. Now, what I'm saying, my learned friend is harping that there is a writ petition. The High Court said to decide whether it is a community land or it is a government land. Ultimately, all those cases, it was not decided. Here a case where it decides and a certificate given, maybe in 2020. That stand as on date. He is asking for allotment which doesn't belong to Union of India. That land belongs to the state. So your lordship has
We have taken your point.
Yes,
Just-
yes, yes.
Just we'll try to find out.
Yes.
My lord, precisely, my lord, the queries followed by your lordship is at page number, my lord, 173. It starts from
173.
3 of my writ petition. This is the, my lord, the first reference, my lord, the applications filed before the district, my lord, in the court of the district and session judge come presiding officer land acquisition, the reference authority section 64, my lord. This is the application filed by the Union of India through ITBP, my lord. And the next page, my lord, relevant is page number, my lord, history, page number 175. The history of Italian occupied by ITBP, my lord, it is given, man. And they are also not disputing these specs, my lord. The land has been taken over from the Darden Assam rifle, my lord. When the, my lord, the land was under active occupation and possessions of the, my lord, ITBP, my lord. The selling other thing transaction made by the, my lord, the party is there to, my lord, it will not have, my lord, the implications on us, my lord. My lord, page number 167, my lord. Para 13. Page 167.
No, this history does not, page 175, you're making about the
Ownership, my lord.
the dispute with regard to ownership.
My lord. Page 167. 170, sorry, I'm 173, 76, 176, madam. 176, madam.
76.
Madam.
Yes, and
176. Para 13, madam.
Yes.
Land in questions belongs to township area, madam. that it is to apprise you in the earlier correspondence that the said land incursions they stated to be the township land, byte number so and so, 4th January 2008. But as per the final notification, the status of the land, the zone, is private land, which is contradicting regarding the status of the land. So the land land is treated as township land, and as such the process of the land acquisition is not requireable. This is the very first when we came to know about the acquisition, the notification issued by the state respondent, then and there, we taken this.
Is the notification there on record? 1/4/1/2008. Is that notification on record?
I have to check out 104 1.
You see, if I have understood the context of law correctly in the state of Arunachal Pradesh, the land belongs to does not belong to the state. Correct. So I'm speaking with reference to Assam land laws, where a town land is merely a classification of the class of land. It may be a village land, it may be a municipal land, it may be a town land. How does it affect the ownership of the person? You see, you have a land here. It was a village land. Now, in passage of time, yesterday, this land was declared to be a town land. Does it change the ownership?
No, man.
Then it may be a town land, it may be whatever land. It's only a class of land.
Therefore, the specific, the earlier owner was Mr.
Your case you are trying to make out is that earlier the page 101 is the original owner. Is not ownership. Now, when in the first point of time you have raised this dispute.
Before that, we were not informed regarding the acquisition, So therefore, another the point
In fact,
raised
you
by
said,
the
in the
ITBP.
last working day, I am good in giving horrible examples. The last working day of the court, while the counsel was arguing, I went to sleep. I did not hear anything. Correct?
Right.
You understand the meaning? So if I am daydreaming, I am sleeping in the day, who will wake me up? You have been fighting for this land for God knows how many years. And now in a writ petition, you are raising a dispute with regard to ownership. You say that nobody informed you. Did you apply under RTI Act and you did not get the information? Did you consult the Deputy Commissioner's office? He did not give you the information. That's why I'm asking, where is the first point of time? You have asked this, you have raised this issue. And in a writ petition, if you have contested in the reference, you have also participated in the award. But this, when the award is passed, you are aware of it.
That is the whole
Can
contention in
we take up this issue as in a writ petition as the original dispute?
My submission is in the entire repetition, our contention is we have not been regarding the acquisition of land to be issued by the
I
state.
gave you that horrible example. I was sleeping. Now can I say that I did not hear both sides when I was sleeping in the courtroom?
The one contention, where we not been information that has been done. State respondent,
No, you never asked. You never asked.
Yes,
who is the owner? Now,
No,
can you raise this?
at that relevant point of time, when the land was already under the positions of the ITBP, they are then taken over from the Assam Rifle, So therefore, we were under impressions that land belongs to the government land. Therefore, the one time settlement,
Theory.
No,
You have assumed something.
For that specific, my lord, may I take your lordships to the page number 176 again, madam?
One second, I'm there.
Para two, my lord.
Yes, I'm there.
Revocation of the notification under urgency clause, madam. He never given requisition to the, my lord, the authorities for the acquisition of land. The notification under urgency clause, 40/1 of the compensation and transfer, land acquisition, rehabilitation, settlement.
No, you show us that it is permissible. You show it is permissible. This land was acquired, taken over long back.
My lord, may kindly
Notification will-
appreciate something. When the land was under the already active position, my lord,
Okay, we also ask you on that. Can you go out, speak to your people and tell us now, when you are handing over possession of the land to the petitioner, to the respondent, you want a revocation?
Yes.
Although we don't have jurisdiction to order a revocation. But still, can you go out, ask your authorities, would they give us the date when you are handing over the land to him? We pass an order today, will he get the land within 7 days?
my lord, that is the contentions, madam, we have raised. my lord.
You ask them, end of the matter. Mr. Das is happy with that.
I told, but for the very first instance, even 40 is not permissible.
Go have a talk with them, tell us within 7 days if you can hand over the land to them, well and good.
Return back. No problem.
Again, my lord. My lord, that is
Because
the
Mr. Kato, very old English proverb. I think I still did not understand that meaning. You can't have a cake and eat it too. You have heard it. You can actually
My lord, at that proceedings, my lord, my lord, ITBP is not in that contentions that, my lord, the appropriately, my lord, the compensation amount will be paid regarding, my lord, the exact, my lord, area is also disputed, my lord. The exact area which has been permitted by the, my lord, the Union of India, my lord, is also, my lord, exceeds, my lord, as per their calculation. But we are in position of the, my lord, the area is also disputed, my lord. Therefore, my lord, time and again, we are saying that we are ready to pay, but we are ready to pay, my lord, the rightful owner with proper, my lord, the verification. ITVP doesn't, my lord, never said, my lord, will not pay. My lord, will pay, my lord.
Mr. Kato, wherever I touch you, things are not falling in the line.
My lord, may I
You see, let me ask you. In civil procedure code, you have to interpret a suit is a suit where somebody finds this pen. You don't know about the owner. Therefore, you go to court and say that I found a pen. There are 3 claimants. Please ask me please tell me whom to give a suit. An interpreted suit is not permissible only in one circumstances, that is Tenancy Act. Tenancy cases, interpreted suit is not permissible. Now, did you deposit the money on protest saying that if there is a third party claim, you will not be liable and therefore please do the necessary investigation? That is one. Second, it is when the initial notification of acquisition is made, it is at that point of time that all determinations with regard to right title interest are adjudicated. Can you tell me about one instance where after gazette notification of land acquisition, this is done? There is only one exception, which is under, what is that provision? 3G of the National Highways Act, where this determination is done by an arbitrator. But in the context of right of fair compensation, can you tell me about a provision where without determination of whose rightful interests are involved, any award is passed? Or any provision of law which empowers an award to be passed without knowing the owner?
Therefore, exactly, they are not in the positions to come with that, the documents by which, the inquiry was caused.
Can't be. You see, they're fundamentally wrong. The reason is under the Land Acquisition Act, Transparency Act, there must be a plan. It's a requirement of law. Rehabilitation resettlement plan. And that is why to escape resettlement plan, the government takes recourse to Section 40, where this plan is not required. So therefore, I'm just thinking aloud, that wherever I'm touching this matter, I find that the things are not in place.
My limited senior counsel is here. My underlying principles of the 2013 Act is something different. It is in case of my limited understanding, is press in case of the press acquisition, where the press acquisition is to be done, but it is in our case, that where the occupation was done long years back and
The notification over here also, when I am touching it, it doesn't fall in place. When the initial notification was made, did you challenge it? Now you will come up and say that, well, nobody informed me that I could challenge.
there is one provision where the willingness certificate has to be given, willingness certificate, that unless willingness certificate is provided by the requiring body, that cannot be initiated,
So
may I take your lordship to the rules?
No, you forget this. Whatever is there in the statute, you forget it for the time being. Have you challenged the notification, acquisition notification on that ground?
Yes,
You have challenged it?
Yes.
Where is that challenge? Where is that prayer? If that is the prayer, you tell us within how many days?
Therefore,
No, we'll allow your petition. Within 7 days, you hand over the land.
Yes.
We are allowing the petition today on that this statement, mere statement. Even if there is no pleading. On your oral prayer, we allow the petition.
I'm sorry, therefore, this morning I prayed for the adjournment of the case for time being, is because I'm not having some record of my own, to fair make submission.
No, you see, you are making a submission. You can't say that you have made a submission without knowing a record.
No, it is in the pleadings, It is in the
Correct.
pleading one.
So we are allowing the petition in that pleading.
But then in that case, may I phrase it, subject to convenience on the part of the Lana Senior Council, matter maybe listed for tomorrow, I'll come with the entire
Tomorrow. Okay.
Everything is in our pleading,
My lord, I will stay back on conditions. He comes to the court and say that we will hand over this particular clause.
No, that we don't know what it does.
No, we fought this case for so many years. Now, honestly, that's honest, I am telling before the court. As
No,
a
that's
senior
okay.
counsel,
But
as a senior counsel, I'm telling, this is the client is not willing to go ahead with it. He said, return the land back to us, we'll be happy.
that's okay. But
Return the land.
tomorrow is,
Clearly, this land,
tomorrow
piece
is-
of land has been taken from.
tomorrow is another day. Tomorrow we don't know what happens.
Yes, well, that's why I'm telling. That's why the first argument which I advanced is that if they return the land, we'll be happy. That return the land. I know 40 is a very difficult, unlike 11. 40, and there are judgments. But even your lordship can allow this, but they have to tell within a period of 7 days they have to return the land to us. I'm sure they will not be able to.
Admittedly,
Yes.
this piece of land has been taken over from the Dadin Assam Rifleman. Assam
Whatever.
Rifleman.
Assam?
Assam Rifleman. Earlier, Assam Rifle was posted,
Whatever.
and it was occupied in the year 2000, 62, from the year 2006, 1962.
No, just tell me.
Well,
Just tell me. You were some time ago, you were arguing that the respondent was not the owner of the land. Correct.
I'm sorry, I'm not good.
You were arguing that respondent was not the owner of the land. You dispute his ownership.
Yes.
Correct.
Yes.
Now, please tell us, under which authority Assam Rifles took over the land?
Admittedly, there was the effect of the position is because during the urgency period, the Chinese aggression period, this land, not only this, entire state, Earlier, the Assam Rifle were posted, madam, in madam, various places. Madam. Thereafter, madam, there is a policy of the government, madam, the Union of India, madam, to replace Assam Rifle from the state of Arunachal Pradesh and inducted, madam, the ITBP to bordering the border areas, madam. That is the whole reason, madam, this problem.
So
Not
according to
only
you-
this case, madam.
according
So
to
many
you-
cases are pending before
No,
decision.
it's okay that according to you, the ITBP
Madam.
is never in possession of the land, but it is the Assam Rifles.
Madam. Since 1962, it was till 2004, it was under the position of the Madam Assam Rifle. And in the year 2005, when the ITBP was inducted in the state of Arunachal Pradesh, madam, we took over the land, madam, with proper, madam, verification, madam.
But then what happens to your argument? You are making inconsistent argument submissions.
So therefore, madam, from the records, we are saying that this
No,
land,
no.
piece of land, madam, therefore, there
Please-
was a order
please-
issued by this honorable court
Please
for
stick
calling
to a
inquiry, madam.
stand. Please stick to a stand. You say that the land is not in your custody, it is in the custody of Assam Rifles. And then you are saying in 2004, you took over. If you make an inconsistent stand, we ask your director, who's the head of ITBP, Director General. We call him in person with all his assistants and records to address the court. You see, the reason is why we want to call the highest authority in ITBP is that you permitted land acquisition notification. Then you say that land acquisition notification, you never asked for the land. You again say that Assam Rifles was earlier in the land and you took over. Now you say you don't have the utility of that land, you want to return it. If you're not the owner, how can you return it? If you're not the owner, how could you get into that land? If you're not paid compensation, what authority, by what authority you are offering the land back to them? It is lawfully theirs. Why we need an authority of the ITBP to return the land to the respondent who is actually the owner? Once you say you are not the owner of the land, you divest yourself of every right to contest in respect of the said land. Or the last and only alternative which I can perceive is to mislead the court. In all these conditions, I have a right to direct the authorities to come and explain before the court.
Well, firstly, madam, I may be allowed to have some
No.
discussion.
You see, when you are standing here, we will presume that you are standing here with all instructions.
Admittedly, madam.
If you have any doubt,
Well, due to my personal difficulties, that
no. If you have any doubt, there is a judgment in GLT by the division bench headed by Justice B.D. Gyani. He said that in context of caveat, when an adjournment was sought for, he authored a judgment and he said, rightfully, that when a counsel stands with a vakalatama, he is appearing with all instructions.
Sure. But sometimes,
No, you can't take the stand. Midway in the writ petition, you are taking too many inconsistent stands.
Well, tomorrow, madam, I'll come. Madam, subject to correction, convenient on the part of the senior counsel, madam. Tomorrow, madam.
Because then we are writing the inconsistent stand in the order.
Well, for
It will
that
not be
matter,
a vague adjournment.
well, I'm sorry, madam, for that matter, madam,
But you see, you are arguing
is madam, days for the,
So let us say one thing. I said tomorrow is another day.
yes, madam.
Tomorrow that I will be able to take the matter is God's will. Tomorrow I'll attend the court and I'll take up his God's will. So my successor in office who reads the order, he will not understand why the matter was adjourned. Why your stand should not be recorded in the order sheet. It will give us clarity. Tomorrow we save time. If I read my own order, I will understand.
Well, firstly, madam,
No, you can't take the stand. Midway in the writ petition, you are taking too many inconsistent stands.
I may be allowed to have some, madam, discussion.
No, you are standing here with all instructions. If you have any doubt, It gives me the handle to call your Director General.
my lord,
Sit down, think fully for 2 minutes. Sit down, think over. I'm not in a hurry to pass an order. Sit down and think over. Or you come after 5 minutes, think over and come after 5 minutes.
then in that case, my lord, may I, may I complete my argument?
Please.
It's because, my lord, it is, my lord, I'm not finding my own copy of writ petitions. Because of that reason, my lord, I may be in difficulty otherwise. My lord, otherwise it is, or everything is on record, my lord. So therefore, my lord, may I pray, my lord?
Yes, yes, definitely. Because you see, I think so. Why I'm saying so is you please come to this affidavit in opposition, page 161. This is in the writ petition.
374 months.
Come to page 165 of the writ petition.
Well, I'm sorry, my lord, I'm not repeating, my lord.
You don't have a copy of the writ petition?
Yes, copy of writ
Writ petition, 374. Come to page 165.
Yes, my lord.
Paragraph 6.
My lord. That the answering deponent's timely begs to submit date. Since there were errors in the land acquisition process and the respondent number 3 fails to comply with the directions issued in the, my lord. This is the exact, my lord, the point I wanted to read.
Correct. I am interested in the last 6 lines.
My lord.
As to
So
the
and so passed by
determination of
the.
ownership of the said land occupied by the then Assam Rifles, now ITBP.
Yes, my lord.
So therefore, you have admitted on affidavit in this court that this land is yours.
My lord.
Therefore, I said that you are taking up inconsistent stand. I am first reading it and then I am pointing it out.
Well, that's because, well, at the very beginning.
Whatever is there, we don't know.
Well,
but your stand is inconsistent is demonstrated by your own affidavit.
Therefore, this honorable court may please to allow the respondent authorities to initiate the legal land acquisition procedure afresh and make necessary changes after obtaining the willingness of the ITBP for the interest of justice. Not only this,
Why
when the
you take that
affidavit.
stand? Why you take that stand? You see, you are saying that please initiate a fresh acquisition process after taking willingness. But if you don't want to return the land, your willingness is inherent.
And for that matter, my lord, the ITBP, my lord, with the sanctions of the ministry, my lord, initiated for the grant of the one-time settlement sanction, my lord, as per the correspondence made by the district administration, my lord.
No, why one-time settlement?
My
You
lord.
don't have willingness, and you say that come for one-time
My lord,
settlement.
this is before, my lord, the notification, my lord. All correspondence was made before notification. Before notification, there were, my lord, the correspondence made between the district administration and the ITBP for payment of the, my lord, land revenue, my lord. May I take your lordships to the, my lord, the annexure? Annexure 1, my lord. Page 43, man, of my writ petition. Type copy is page number 44, my lord. By virtue of, my lord, this situation, my lord, the letter, my lord, all were initiated for the transfer of the land to regularize, my lord, the ownership of the.
You have any idea of a few legal terms, which is called waiver, estoppel?
My lord.
You have any idea?
My lord.
But when you are asking us to read.
My lord, may I read, my lord, the conditions of.
No, but what is the purpose of reading? That's why I'm asking before you read. Are you aware of this term and the meaning of the words? Waiver and estoppel. You're aware of it. Then why read this and waste time of the court?
Just to clarify the factual terms, man.
No.
Because of the whole reason, my lord.
No. Once you take a plea, here you say, reference to so and so, and then hereby requested to deposit so and so.
My lord. This is the correspondence made between the made by the district.
This is 2008.
2008.
Sorry, madam, much
Yes.
before the
So in
notification.
2008, you don't express your unwillingness. 2013 Act came later on. When you say that the land is already in your possession,
My lord.
in the affidavit page 165, is a willingness again required?
My lord,
You take
if-
out the position
my
that
lord,
you asked for
that is the,
willingness.
my lord, the whole, my lord, the crux of the case. If, my lord, at all, my lord, required to be issued by, lord, by way of acquisition, my lord, at least, my lord, what our contention is, my lord, at least, my lord, the willingness certificate has to be, my lord, initiated, my lord, from the issued from the, my lord, the requiring body, my lord.
For that, you'll have to mandatorily require to give back the land, let them enjoy the ownership even for a day. Then you make a requisition to this central to the state government to acquire the land. You can't have that proverb, have a cake and eat it too. You want to retain the land and harass the respondent. And obviously, we take an adverse presumption why you want to do it. Your authorities have now seen the huge amount of compensation, and therefore this objection. We draw an adverse inference against you and your officers.
And my lord, another important documents, my lord, why this is similar to the, my lord, the writ appeal number, page number, my lord, 53, my lord.
But mind it, when I'm saying it, I am intent to record it also. We ask for an in-house inquiry. Why they have raised this objection now? We'll be compelled to do it. You can't take inconsistent plea and get away.
Or, my lord,
Mr. Kato,
my lord,
Mr. Kato, I'll tell you, I have very deep regard to the institution. I would be the last person to use the term that people come to the court to play. This is an institution where we dispense with justice. So somebody can't come into the courtroom and then play it like an arena. It's not a ping pong arena where you can be permitted to take inconsistent plea and delay the dispensation of justice. Because if you find that this somebody is making an attempt to play in the courtroom, then the institution of Temple of Justice goes. Then we are in a playground. That can't be allowed to happen in a courtroom.
then, my lord, may leave it to your lordships, my lord, may pass the appropriate order, my lord. Otherwise, my lord, this is the whole contentions of the ITBP, my lord.
Page
One-
number
Page number 53, my lord.
53.
My lord. This has been addressed to the, my lord, Deputy Commissioner, respondent number 3 by the ITBP, my lord. It was on 4th September 2009, my lord. Addressed to the Deputy Commissioner, my lord, same district. I am directed to say that the Assam Rifles was in occupations of the land in the following border, the outpost since 1950, and and above land have already been handed over to the ITBP force in 2005 as per MHA order. My lord, land specifically in question is serial number 5, my lord, Italian. And the area, total area is given, my lord, 3 acres. And my lord, the year of possession 1959, my lord. And this is not the only, my lord, the Anini, Alinea, Dembian, Mipi, Malinie is pending in connection to, my lord, the writ appeal number 42 and 43, 41, 42, my lord. Serial number 1, 2, 3, 4, and 6 is pending before pending in connections to the writ appeal number 40, 41, 42, 41, 42. Sorry, man.
Yes.
And page number, my lord, 54, my lord. This letter has been issued by the, my lord, Deputy Commissioner to the ITPP for payment of, my lord, the one-time payment of land revenue, my lord.
Yes. What do you want to convey by referring to page 54?
54 is the, my lord, is the correspondence made by the, my lord, the Deputy Commissioner to the ITPP for one-time settlement, my lord.
You are sure? That is the meaning of that letter?
My lord, may I read, my lord, may I read, my lord?
No, you read it because I have read it. And I just want you to be whether you are sure what you are saying is correct.
My lord, deposited, my lord, it has been directed to deposit the amount.
That's what I am saying. I am asking a question whether what you are reading is what you are reading and conveying, whether that is right interpretation of the letter or not. Are you saying it with conviction? What you are saying?
My lord, this is the, my submission is, this is the correspondence made by the the Deputy Commissioner to the ITPP for settlement of the, my lord, payment of the land revenue on one time, my lord.
Now you are using the correct word, land revenue.
Yes, ma'am.
Land revenue and compensation are two different things.
Yes, ma'am.
Then
And my lord, same, my lord, is,
why you are making things so clear? The court. Is that you want to say?
just, my lord, I am using the word, my lord, unintentionally, my lord, but my lord, my lord, I have, my lord,
You see, I have a very different philosophy. I forget the sin. Because in our religion, we are taught that you please forget the sin. It never teaches us forget the sinner. In our upbringing, the message ingrained in us is that please forgive the sin. Man can do sin for many reasons. A small boy does not get something to eat, he steals bread. So forget the sin. But it never says forget the sinner. If you make incorrect submissions, you are making us averse to you forever. You are making us change the character. For a brief, you want to us to change my character?
I'm sorry, my lord, that was my lord.
You see, your case is very, very explicitly clear. Number one, you say in 1959, the land in Italian is taken by Assam Rifles. 2005, you say that 2005, the land was handed over to you without any payment. And this you confirm sometime in 2009. There's a letter somewhere in 2009. You confirm that you have received the land. Now, 2013 Act comes into play. And then we have a scheme of determination of compensation. Till the time all these things are done, you never complain. Once an award is passed, then at each and every moment, you are raising objections one after the other. One ground or the other ground or the third ground or the fourth ground. Now please tell us, you understand the principle of Order 2, Rule 2, Civil Procedure Code. It squarely applies to a writ petition. You can't file successive writ petition for different prayers. You adjudicate, you give into adjudication, you present for adjudication objections at various stages. Every time you take a new objection. That's why when I asked you that question, what is the first in point of time you raised the objection as to ownership, you could not show. And despite that, we are listening to you. We are thinking that the state has to pay or the union government has to pay a huge amount. We are just listening to you. It does not make it that we don't understand. A plain written English we can't understand. And the purport of the entire spread over litigation we can't understand. Now tell us, for the time being, you transpose yourself and come to Mr. Das's place. Let Mr. Das be here and you be there. Will you like that? Supposing you are at the receiving end at Mrs. Das's shoes, will you like it? Every time you stand up in the court, you find new things taken up. Answer would be no. If you say yes, then I have 2 more points. And the first point would be, how much compensatory cost? The second is, why for taking up such plea at belated stage? All officers who are parties to this spread over litigation, their conduct should not be examined by the Ministry of Home Affairs. That is the 2 things which I am not asking now. Then you can come to court and turn this temple of justice to a playing arena.
Just, in that,
Nothing you say makes makes out any point.
This successive petition, writ petition has been filed. That's because there is no remedy, remedy lays in for the requiring body. When
Your masters are the authors of this act.
70.
545 very learned people have framed this law. Can we presume, because of your submission, that these 545 people who constitute the parliament do not know anything?
63.
And if you challenge the law, it would have gone to the division bench. This is something which we will permit you to argue. Because we don't have, as a single judge, I don't have jurisdiction to hear that.
Just for a moment, may I take a lordship to page number, section 63 of the 2013.
63.
Section
You see, after 95, what remains in 63 or 64, whatever?
60. If lordship is having same book, page number 37, 67, 63, section 63, jurisdiction of civil court, barred.
That we are aware. In land laws, it's not the first time.
This is the whole reason, that this writ petition has
No,
been
in the
prepared.
past, it was also covered under, this land production was covered under Schedule 9 of the Constitution of India. They are not justiciable.
No civil courts other than the High Court under Article 226 or Article 27 of the Constitution of or the Supreme Court shall have jurisdiction to entertain any disputes relating to land acquisition in respect of which the collector or the authority empowered by or under this act, and no injunction shall be granted by any court in respect of any other such matter. Section 63.
You see, that's what I was searching. In the old land act, I was more comfortable, but in this new act, I have to read. Come to section 15.
15.
1 5.
Yes, ma'am.
Any
Hearing of
person interested
objections.
in the land which has been notified under subsection 1 of section 11 as being required or likely to be required for a public purpose may within 60 days from the date of publication of the premium object notification object to the area the suitability of land proposed to be acquired. So therefore, when you are saying that this land is not required, the question was when the first point of time you took that plea, that is based on section 15(1)(a). Second, justification offered for public purpose. Number 2, finding of the social impact assessment report. So now therefore, and 3 says decision of the appropriate government on objection made is proper. Now can you raise a dispute? I refer to interpret a suit. Can you raise a dispute that the correct person has not come? And second question, which is correlated to the first one, is whether the erstwhile owner of which you have referred to the earlier writ petition, page 101, did he apply before you for compensation? Number 3, in any case where even if a final decree is passed, a decree can already also been assigned. Mr. Kato,
Madam.
are you aware that a decree passed in favor of someone can be assigned? It can be sold.
Admitted to know.
Correct. It can be sold. It can be transferred. It's a transferable property. Fourth, in a doctrine of lease pendants under section 52, what is prohibited is only that the decree is binding on the subsequent purchaser. So even if Mr. Das was not the owner, by some reason he is now projecting himself to be the owner, he'll be bound by the decree, and decree is in his favor. Therefore, wherever we are touching this matter, we are finding that the Union of India is trying to deprive the petitioner respondent of his property, which is prohibitive under Article 300A. 301 or 300A? No one should be deprived of the property without due process of law.
Well, that is the whole things.
So nothing remains.
I leave it
in
to
this
you, Lord.
repetition. Then nothing remains in this repetition. But we give you an option. That option can be exercised within 3 working days from today. If you want to return the land, do it within 7 days. And that part of the compensation for the land given would not be required to be paid. That option we are giving it to you. 3 working days from today, you exercise that option, failing which you will not be able to raise that objection. That right is gone forever. This I heard. This I am Katul under DSGI preparing for the petitioners. Also heard. Mr. Kandu, we have not heard you. You want to say anything?
Hello. Response to the
Respondent matter. Denied that matter. The ever having pass matter. Notification has been issued. That matter, what is matter? W41 matter is pending for disposal matter. The notification issued to that regard was different matter. And the notification for the land matter. Particularly, it was issued under unnecessary clause. And the location itself matter is distinct matter, distinct and different matter. In any case, matter, my submission would be that matter. My friend for the union is saying that there was no union certificate. Now the issue is matter, if they want the land matter, they may release a compensation. If they don't want, they can return back the land.
That you can't say. As a land acquiring authority.
Yes, madam, we have done our duty, madam.
No, not that. But this is a claim you can't make.
Yes.
Return, because there is nothing in the act which asks for return.
If it is,
After notification.
if they are not willing to pay the compensation, madam, the only recourse, madam, I could see land.
No, it may happen.
With the actual owner, madam.
That way,
And madam, regarding it's a dispute of the ownership, madam. They are asking on the ownership, madam. There is no dispute at all, madam. They are not showing anything that there is a dispute over the land, madam. Only they are saying that who is the actual owner of the land. Actual owner of the land, madam, by annexing document. By the President number 4 has proved it, madam. And this is for the government acquiring authority to decide who is the owner. They are the requiring body. They have to pay the compensation and land has to be given to them after acquisition of the land. If at all there was a dispute, my lord, Deputy Commissioner, who is the land acquiring authority, my lord, he would have not acquired the land, madam. There are no dispute, my lord. This notice for objection. There is no objection.
Those things are not on record. Issuance of advertisements and all this, this is not on record. We did not find it. Is it there in this petition? I did not notice it.
It is not there. In any case, my lord. No, notice will not come in. There is no notice. There is no notice so far as 40, but joint survey inspection was done by them and in presence of the government officials. 101, if your lordship looks into 101 of the act, 101, it is return of unutilized land. 101. When any land acquired under this act,
that will not apply.
that's why I'm saying.
It is only when the land acquired remains unutilized for a period of 5 years.
That is why it will not apply. That's why I'm saying. They have utilized it. They have utilized.
No, they have not stated that it's not utilized. They say that there is no requirement, helipad land. I think that is the word.
No,
They don't have requirement for that land, correct?
Yes.
That is the stand. It doesn't say that it's unutilized.
But it was throughout, it was with their position.
No, that is.
It was throughout with their position.
Okay. So the evidence also heard Mr. D. Kamduk, Leonard. No, first is Chief Secretary. No, Chief Secretary will be Mr. S. Tapin, Leonard, Senior Government Advocate, appearing for respondent number 1. Mr. M. Kamduk, Leonard, Standing Counsel for the Land Management Department, representing respondent numbers 2 and 3.
1 and 3.
You are with 1 and 3. 1 and 3. And he's for number 2. And Mr. D. Das, Leonard Senior Counsel, assisted by Mr. K. Mohammed, Counsel for respondent number 4. Next one. The petitioners herein are the Union of India, comma, represented by the Director General, comma, ITBP, under Ministry of Home Affairs, comma, Government of India. This is number one, huh? Number one. Number two, the Inspector General, comma, Northeast Frontier Headquarter, ITBP, and the petitioner number three is the Deputy Inspector General, comma, Section Headquarter, Dibrugarh, comma, ITBP, and the petitioner number four is the Commandant, comma, 9th ITBP, comma, Lohitpur, LOHITPUR, comma, in the district of Lohit, full stop. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioners have assailed the notification dated 21/8/2019, that is page number 21/8/2019, don't type the page number, this is only for your reference. Huh? Mr. Kato, which is the 21/8/19, where is that? 21/8. The impure notification.
158 and 151.
158, 159.
158 and 151. 158. 21 of August. Sorry. One 158.
Published in the Arunachal Pradesh Gazette Extraordinary, dated 26/9/2019, as well as the Land Acquisition Award. Which page is that? 16/2020. Page 68. No, not 68.
Madam, the award is 150 per month, 1st June 2021. 150.
What do you find in my affidavit at page 68? My affidavit at page 68.
No, Mr. Kato, which page do you say?
154, madam.
154.
Annexure 8. award dated, my lord, 1st June 2021.
Yes. It will be more convenient, Mr. Das, from, it will be more convenient from
Yes,
Mr. On the question. Award, land acquisition award dated 1/6/2020. Passed by the Deputy Commissioner, Dibang Valley District, Anini. With a prayer to set aside and quash the said notification and award. Stop. Next para. It may be mentioned that by an order dated Mr. Das, where is that stay order in IA 48? Page IA 48, where is the order of stay?
Stay
Which
of
you have- for IA 48, which stay order you? have
Of the
asked for?
order which has been, which is challenged before this court.
In IA 48,
Yes, yes.
which page is that order?
This order is at page 9, which is 17/5/2023. One second, one second.
75.
Sorry,
Oh, that is page 18.
page 18. This is not the state, it is wait till the 41 is being decided. Page 18.
If I have 219, this case.
48. IA 48 of 2000.
No, the record is not there. 219. Mr. Das, at
Yes.
page 18,
Yes,
there's a reference to IA 219. Where is that record? It's connected which writ petition? IA 48,
is
page
number,
18
yes,
is connected with which writ
219.
petition?
The Union of India has filed. Yes, one second. Once.
Oh, okay. You just say 18, that in. Something is wrong. The stay order must have been passed in the writ petition.
Where, which stay, which stay?
48 is filed for what purpose?
48, for recalling of the order of page 18. page 18, recalling of this order.
My lord, if I remember
17.5
correctly, this has been disposed of, my lord.
Huh?
This has been disposed of, my lord. If I am
No, this,
remember
this
correctly. my lord.
order is passed
On
But because
75.
in 370. Okay,
Four.
in 374, okay.
My lord, in 374, my lord,
Okay.
2 IA was passed, filed by the Union of India as well as the private respondent, my lord, for my lord, releasing of the statutory deposit amount, my lord.
Okay.
And your lordship has already passed an order.
No, my difficulty is that I'm not finding that file, 219.
48 or
219, filed by the Union of India for my lord, the releasing of the amount, my lord, this statutory amount,
For not releasing the amount.
for
refund of the money.
returned the money.
Return of the money.
Oh, okay. Next, it may be mentioned that in connection with this writ petition, comma, no, this is not in this writ petition. No, this IU 219 is not in this writ petition. It is in LA appeal. LA appeal is there.
Yes. LA appeal is, my lord will find.
This is item number.
Yes.
Huh?
LA appeal has been disposed of by this court. This is your lordship will find that order. By the judgment.
Mr. That's what is happening. I am telling you. This page 18 of 48.
Yes.
Has a reference to IAS Civil 219.
Yes, I'm just looking
Now,
into it.
IAS 219 is connected with land appeal.
Land appeal 1.
So it could not have been here.
1.
That is why the difficulty.
One second.
And this order is passed in common with 219, 168.
No,
168 is in the writ petition, so it could not have been connected.
No, there is one reference. I'll just tell your lordship that is there.
Right, it's okay.
I found yesterday somewhere.
We'll clarify it.
Yes.
नहीं उसको छोड़ दीजिए ये ऑर्डर इसमें टाइप नहीं होना चाहिए था not have been typed here 219 one is LA appeal would not have been typed here.
Therefore, my lord, this IA is not in connection to 370.
That's why it could not have been in this order. That's why we'll have to correct it. Otherwise, there will be difficulties again. See, we mentioned that in connection with this writ petition, comma, the writ petition. An order was passed on 17/5/2023 by which on being apprised to this court that identical issue pertaining to another plot of land is the subject matter before the Honorable Division Bench in WA 41 of 2022, comma, which is pending consideration, comma, in the interest of justice, comma, the proceedings of this something is wrong. The proceedings of IA Civil 219 AP of 2022 with WPC 219 AP of 2022 with IA Civil 168 AP of 2022 was stayed. Full stop. It is clarified that IA 219 of 2022 has been filed in connection with LA Appeal number 1 AP of 2021. Rate appeal 219, rate petition 219. I think. तो 219 है हाँ? इसमें चेक कीजिए 219 है नहीं अपना इसमें सिस्टम में चेक कीजिए 219 का लोकेशन This is what is happening, Mr. Das.
I'm sorry.
And Mr. Kanto. Sorry, Mr. Kato. Just pass it on. Just give it to.
This is a stay order, I think.
But
The
it is
refund
passed
of
in a
the
wrong-
dictator.
It is passed in a wrong IAN petition. You see the heading 219 in 219.
Oh, 219.
It's not connected with
Yes,
the
yes,
219 is IA land acquisition, but 219 rate petition is now not connected. And this stay order is in another IA.
Yes.
That is also unconnected.
Not connected.
Unless I rectify the order. What are we hearing today? IA 48 is for what?
For,
No order.
Or already disposed of.
There is no order in this rate petition 374. Where
But-
we are hearing it?
but link case your lordship will kindly see.
No, but
It's
you
a
see,
link.
I have shown you the order.
I have seen.
How this link
But-
has come?
This morning, my lord, I made prayer for my lord, gentlemen. I moved to, my
No,
lord, there
no,
is
we-
no order as such in the
We'll make it all
374.
right. This is 319. So accordingly, though the order, though the order dated 17/5/2023 is shown to have been passed in IA Civil 219 AP of 2022 with WPC 219 AP of 2022 with IA Civil 168 AP of 2022, but from the facts and circumstances of this writ petition, it appears that the said stay order was intended to be applied in the proceedings of WPC, in the present writ petition, i.e. WPC 374 AP of 2022. Full stop. It may also be mentioned that in the certified copy of the order dated 17/5/2023, perhaps due to inadvertence, IA Civil 219 of 2022 as well as IA Civil 168 of 2022 are linked with the proceedings of this writ petition, i.e. WPC 374 of 2022. Full stop. This is also factually incorrect because both IA 219 of 2022 and IA Civil 168 of 2022 are actually linked with LA Appeal number 1 AP of 2021.
This one.
Full stop. Therefore, this clarification therefore, this clarificatory note is made in this order to clarify that the interim order dated 17/5/2023 was passed by this court in connection with WBC 374 AP of 2022. Correct.
Corrected.
Actually, I have to correct it.
Yes.
Because both are
Yes.
in land appeal. Then this why 48 we are hearing now. So it would be infructuous.
Yes, yes.
That's why we have to correct it. Next matter. It appears from copy of letter dated 4/9/2009, written by the Commandant, 9th Battalion, ITBP, and annexed to this repetition as Annexure 1 collie. Collie is within bracket. The Deputy Commissioner, Upper Dibang Valley, Anini, District Anini, was informed that the concerned land in this repetition, which is land at village Italin. What is the spelling of Italin? Etalin. Italin, measuring 3 acres, was taken in possession by the Assam Rifles in the year 1959. And along with description of other land, other 5 plots of land mentioned therein, it has been stated in the said letter that the lands were in occupation with Assam Rifles since 1950, and the same was handed over, and all the 6 plots of land were including the land of Itarin, which is the subject matter of this repetition, was handed over to ITBP force in the year 2005 as per orders of Ministry of Home Affairs. Accordingly, the respondent number petitioner number 4 had made a prayer before the Deputy Commissioner, Anini, for exemption of payment of one-time land value, and the land be transferred in the name of ITBP force. And it was also mentioned that all the lands had earlier been transferred in the name of Assam Rifles without any cost. Mr. Kato,
Well,
in support of page 53, do you have any document?
page number.
Page 53 of your writ petition. Do you have any document? You are saying here that the land was transferred to Assam Rifles. To show transfer, have you annexed any land, any document here? Because I have not found
It was under process for the transfer, madam. And my lord, it was under process for the transfer.
No.
My lord, documents, my lord, taken
See,
over
read this
from the Assam
document. I
Rifle.
am asking you for the second time. Here you say that the land was earlier transferred in the name of Assam Rifles, free of cost. My question is, with regard to transfer, is there any document on record to Assam Rifles?
My lord, I'm sorry
I have
that,
not found any.
that must be, my lord, available with the department, my lord. I'm sorry, my lord, I have not annexed copy of it.
However, on a query of the court, the learned DSGI has stated that no such document is made a part of writ petition to show that earlier the land was transferred to Assam Rifles free of cost. Next one. Next one. The case of the petitioners is that by order passed by this court in WPC 11 AP of 2017, WPC 74 AP of 2017, WPC 77 AP of 2017, WPC 78 AP of 2017, WPC 79 AP of 2017, and WPC 80 AP of 2017, the Deputy Commissioner, Anini, was directed to make an inquiry and ascertain as to whether the land in question was a government land or a community land. However, without complying with the orders passed in those writ petitions, and without any requisition or initiation from the ITBP, the notification dated 21/8/2019, which was published in the Arunachal Pradesh Gazette on 26/9/2019, which is impugned in this writ petition, was issued by the Secretary, Land Management, Government of Arunachal Pradesh, within bracket respondent number 2. It is projected that the land acquisition notification was issued without consulting the petitioners. It is also projected that consequently, the Deputy Commissioner Land Acquisition Authority, Dibang Valley District, within bracket respondent number 3, passed the land acquisition award on 1/6/2020. Please tell me if I'm wrong anywhere. Please point it out if I'm wrong anywhere. Next paragraph. Aggrieved by the award dated 1/6/2020, The petitioner number 4, i.e. the Commandant, 9th Battalion, ITBP, had filed an objection under section 64 of the, just write the full name, right to fair compensations and so. Right to fair compensation. Transparency, give the full name, huh? Right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act, 2013. Then say within bracket, hereinafter referred to as the 2013 Act. Full stop. The said objection was filed before the Deputy Commissioner cum Land Acquisition Authority, within bracket respondent number 3. Full stop. The said appeal, said objection was disposed of by order dated 7/5/2021. Where is this 7/5/2021? Which page? Page 127. No, not 127.
173.
173.
73.
73. No, this is objection. Where is the order?
Order, my lord.
7/5/21.
Page number 181.
161.
181.
181.
81.
No, that's right. Something is wrong. This 64 application was filed before the Court of District Judge.
Page.
District Judge, no, not before the Deputy Commissioner. No. Say that this section 64 was filed before the Court of District Judge cum Presiding Officer, Land Acquisition, etc., East Sessions Division, Teju.
I'll take just leave for one.
The said objection was disposed of when it was registered as reference case number
One.
reference case number 1/DV/2021. This is page 181. And the learned district judge come presiding officer, comma, land acquisition, comma, etc. Had passed a judgment on order dated 7/5/2021. By which the said objection was disposed of by directing the Union of India through the respondent number 4 to make payment of compensation amount of rupees 83,08,331 to the petitioner within a period of 2 months with interest at the rate of 6% from the date of award till realization. Full stop. The said judgment an order dated 7/5/2021. Make it different paragraph. 7/5/2021 was assailed by the Union of India by filing LA Appeal number 1 of 2021 under section 74 of the 2013 Act. Full stop. This court, by judgment and order dated 21/2/2022, held that the learned court dealing with the reference had failed to address the issues raised by the petitioners, by the Union of India. In its petition under section 64, and accordingly, for reasons assigned, the interim judgment and order dated 7/5/2021, passed by the learned district judge, Teju, was set aside, and the matter was remanded back to the said learned court for a fresh decision. Full stop. Next para. As a passing remark, it would be appropriate to make a mention herein that as per the documents annexed in the copy of award passed by the Deputy Commissioner Anini, comma, the name of the beneficiary of the award is not recorded. The beneficiary of the beneficiary of the award is recorded as the petitioner, namely Rohit Meli, MELE. Full stop. The application under section 64 of the 2013 Act is filed by the Union of India, represented by the Commandant, 9th ITBP, and the land LA Appeal number 1 of 2021 was also filed by the Union of India, represented by respondent number 4. I don't say that, strike it out, not required. Strike that paragraph. Strike out. Huh? Huh. The entire part, it may be, it's a passing it back, when I said, strike it out. Next part. On the matter being remanded, comma, the learned district judge reheard the matter and by order dated 27/7/2022, passed a reference case number 1 within bracket DV, bracket closed, oblique 2021, comma, in light of section 95 within bracket 2 of the 2013 Act, which creates an embargo upon the beneficiary for whom the land was acquired to file a reference, comma, it was held that the reference was not maintainable and this reference was dismissed on the ground of jurisdiction. Full stop. Next one. The learned counsel for the petitioner has submitted that the petitioners dispute the title of the respondent over the land on which land acquisition compensation was awarded. Full stop. By referring to the cost statement of WPC 78 AP of 2017, which appears in the certified copy of order dated 14/3/2017, passed in the said writ petition. Committee submitted that the said writ petition was filed by Sri Nagasi, NGASI, MENA, MENA. Accordingly, it is submitted that the land acquisition award could not have been passed in favor of the present writ petitioner, namely, sorry, the respondent number. Respondent number 4, namely Rohit, ROHIT, Mili, MELE. Accordingly, committee submitted that by virtue of orders passed by this court in WBC 11 AP of 2017 and other connected writ petitions referred above, there was required for a determination to be made as to who was the owner of the land. And in absence of such determination, the award stated to be not sustainable. Referring to the objections raised before the Deputy Commissioner Anini on 9/6/2000, by letter dated 9/6/2016, it is submitted that the land was in a township area and the land area was less. No, where you have said that this land is a township land, which page you have referred?
To that effect, no inquiry was caused, madam. Inquiry direction was given, but nothing has been done. So therefore, as till now, madam, but the ownership of the land is not yet decided.
No, yes, but you refer to that one page where you stated that the land is it township land where I mean it's not the land of the petitioner respondent for. You showed us a letter
My lord,
where you said that it's a township
it is
land.
in
Where is that?
page number, my lord, 176, my lord.
176.
176, my lord. Para 13, my lord.
176. No, not this. There was a letter you stated you had submitted that the land was a township land. I made a comment that it's a township land. It can be converted into a village land or converted. It was a conversion of land, class of land. Where is that letter? The land was a township land, and how it could have been owned by the respondent before. Full stop. In terms of the various letters and documents on record, the learned DSGI has further submitted that some part of the land which was acquired by the impure notification is no longer necessary for the purposes of ITBP. And therefore, without an appropriate requisition, the land in question could not have been acquired by the impure notification. Referring to a letter dated 26/2012 by the Deputy Commissioner to Dibang Valley District to the Post Commander, 9th Battalion, ITBP. It is submitted that initially an exercise was being carried out for one-time payment of land revenue. And therefore it is submitted that the initiation of the acquisition proceedings was without consultation of the petitioners and for which it is illegal. And the same is required to be set aside. Mr. Kato, anything I have left out? Anything I have left out as part of your submissions? Have I left out anything? No other point was argued by the learned DSGI. Next one. Per contra, the learned senior counsel for the respondent number 4. Just say respondent number, land management respondent number 2. Mr. D. Kandu, learned standing counsel for the land management, has submitted that from the land possession certificate issued by the land ownership certificate dated 22/6/2020. Where is that? Land possession certificate. Mr. Das, where is that land possession certificate?
Land possession certificate, your lordship will find at page 147 in my affidavit in opposition.
147.
147. 147
of the writ petition.
Of the affidavit in opposition in connection with the writ petition.
No. 1/6/2020. Issued by the Deputy Commissioner, Dibang Valley, Anini. It is submitted that there is no dispute with regard to the land ownership of the petitioner. As it has been certified that the respondent number 4 has inherited the said land from his grandparents. So accordingly, it is submitted that the respondent number 2 supports the award dated 17/12/2019. For sum of rupees. For a sum of rupees 83,08,331. Next one. The learned senior counsel for the respondent number 4. For the comment, Mr. Tapin, you have anything to say? No. Close to. Insofar as the learned senior government advocate is stand in the case is concerned, it submitted that the state has a neutral stand and he supports the award, the land acquisition award issued by the Deputy Commissioner for the Bang Valley District. Next, the learned senior counsel for the respondent number 4. Has submitted that the award dated 17/12/2019 was initially for a sum of rupees 85,53,086. But owing to subsequent notification dated 9/1/2015, by which multiplication factor was settled, the LA award dated 1/6/2020 was passed for an altered amount of rupees 83,08,311. So it is submitted that prior to the issuance of the said award, by a letter dated 13/2/2020, the Department of Land Management through its director ex officio joint secretary had issued a letter dated 13/2/2020, conveying the approval in respect of the award. So it is also submitted that on inquiry being made by the by the petitioner number 4, the Deputy Commissioner, Dibang Valley District, by a letter dated 2/6/2020, gave reply to the specific query, which was made by letter dated 12/2/2020, and against first query, spot verification, sorry, the spot joint verification report was enclosed. And with regard to the second query, it was mentioned that no value of trees and plants were estimated for valuation of compensation, which was accepted by the board members. And with regard to third query, the land ownership certificate was enclosed thereto. Full stop. Accordingly, it is submitted that it is too late in the day for the petitioners to challenge the ownership of the respondent for in respect of the acquired land. Full stop. By letter dated 12/2/2020, the respondent, the petitioner number 4 was requested to deposit the compensation amount. Full stop. Next para, it is submitted that in view of the express bar, which is prescribed under section under the proviso to subsection 2 of section 95 of the 2013 Act. It was not open to the petitioners to demand a reference under section 64 of the said Act, said 2013 Act, and accordingly it is submitted that the learned district judge had rightly dismissed the reference made under section 64 of the 2013 Act as not maintainable. So that's anything I've left out. I think that's all. From the, I'm sorry, see, peruse the materials available on record. In the repetition as well as connected IS bill 48. Before. There's no material on record to show that initially when the land was by Assam Rifles in 1959, the land had been acquired in the representations letters by the IDBP to the committee, letter, I'm somehow missing it today. That left that it was transferred in the name of Assam Rifles. That letter.
Page 53.
Was transferred in the name of Assam Rifles, which is specifically referred in the letter dated 4/9/2009 by the petitioner number 4 to the Deputy Commissioner. However, on a query of the court, the learned DIG has submitted that there is a document on record to show that the land specifically in the village was transferred in the name of Assam Rifles. Therefore, notwithstanding that the land is being occupied by ITBP through Assam Rifles in the year 1950 and or 1959, remains the land remained in the Assam Rifles and thereafter in possession of the ITBP without the land being formally acquired. the learned counsel for the had the petition was never obtained before the land acquisition took place. So however, it is noted never just family that they prior to this requisition of the prior to the requisition, the petitioners had not assailed the notification of land acquisition. Therefore, I of the 2013 Act, which was dismissed. Dated
Seven, 2020.
no initial order was initial order. No?
Initial is page number. Two thousand.
Huh?
Initial first 7 May 2021.
Was passed on 7/5/2021. No, so sorry, order dated 7/5/2021 was assailed by filing Appeal number 1 of 2021. The order dated 21/2/2022 passed in LA Appeal number 1 does not reflect that this is drawn taken by the petitioner earlier. What's it context? Come on. The court is of considered opinion that even in action of the repetition, principle of Rule 2 of Order 2 of the Civil Procedure Code is applicable, as the petitioner ought to have raised the plea earlier in point of time to the effect that the acquisition was without any requisition by the petitioners. Therefore, comma, as the petition seek relief in the proceedings of one of Number 1 of 2020. And appeal number 1 of 2021. The prayer. The submission made in the petition that the acquisition was made in respect of the land without any requisition is not found sustainable. Full stop. By referring to the plea taken by the respondents, the learned DSG has submitted that there is no requirement for some part of the land which could be denotified. The court is of the considered opinion that when the Union of India, through its agencies like the Assam Rifles, as well as IT, has been occupying the land in question from the year 1950 and of the God 1959. It is too late in the day in the year 2024. How many years? After 65. Thank you. After 65 years, to take a plea that a part of the land is not required. So, at least it's not expected for Union of India, who is supposed to be a role model, to have occupied the land for 65 years and to say that they do not have use for a portion of land. After the petitioner or his ancestors or through anybody else through whom the petitioner is claiming or the fruits of land acquisition.
Denying the respondent. Denying respondent number 4.
Full stop. Next one. Be that as it may, although it is not a prayer made in the petition for return of the land, but having heard the land DSG with the consent given by the learned senior counsel for the respondent of 4, in the event the Union of India takes a decision that the entire land of the petitioner is not required, from today, i.e. within 19/9/2020, and the same be communicated to the petitioner. Sorry, respond and disclose their readiness and willingness to hand over the land, entire land, to the petitioner within 7 working days. It would be open to the Union of India to make such an offer to the respondent of 4. And it will be open to the respondent of 4 to take an appropriate decision and communicate it to the concerned authorities within 2 working days from the date of receipt of such communication. Correct? Next part. As this part of the order is not the relief prayed for, the court is inclined to provide that in the event the timeline mentioned above is not adhered to, the said offer will stand lapsed to the petitioners, and no prayer for extension of shall be entertained in future. Next paragraph.
Well, this is small submission. Just a small submission.
Pardon? You want to give it?
Decision process is another, so.
No, we don't know the, don't, you, if you go by your channel, you see, I have a notion, I don't know, I may be horribly wrong, but I'm quick in forming notions which may be totally wrong. You see, at the discretion, Ministry of Home Affairs may take on requisition the biggest field available in Itanagar, engage 1,000 people to sit on each table, and then say that we are passing this document from table to table.
Well, at least a month time maybe.
No, I don't know.
No.
You see, this is not a part of your prayer. You made a submission, we allowed. Now let your highest authority take a decision. 7 days means 7 days. We don't allow that, what you call, dheere dheere chalta hai. That must stop somewhere. This is an exceptional offer given by the court. This is an order where I don't find any precedence to return the land. And therefore, no extension of time. To stop. It is made clear that there would be no extension of time because of the fact that under the Land Acquisition 2013 Act, it is not open for the either for the state or for the requiring authority to alter the position, except under circumstances provided under Section 101 of the 2013 Act. Next paragraph. It is also interesting to note that on the prayer made by the petitioners, petitioner number 1 represented by petitioner number 4, in early appeal number 1 of 2021, that order dated 27/7/2022 was passed by the London District Judge in connection with reference case number 1 within bracket DV of 2021. Full stop. The said order is not assailed by the petitioners. Therefore, the said order dated 27/7/2022 has attained finality. Full stop. Accordingly, without any challenge to the said order dated 27/2/2022 passed in reference case number 1 DV of 2021, the challenge made in this repetition to the land acquisition notification dated 21/8/2019, which was published in the Arunachal Pradesh Gazette on 26/9/2019, as well as the award dated 1/6/2020, cannot be held to be maintainable. Full stop. With the waiver to challenge the order dated 27/7/2022, the challenge to the land acquisition notification as well as award is not found sustainable. There is no challenge.
No challenge.
Next paragraph. Before just make a note there. This will go ahead when I have said that the petitioner is the owner of land. At that part, you just add it. The learned DSGI had referred that the original owner of the land was Nagase NGASI MENA and not the respondent number 4, comma. The court is of the considered opinion that such issues ought to have been raised before the land acquisition authority. Because the court will be slow to issue a declaration as to the right title and interest of a person in a writ petition when the title of the respondent to the land in question is not in question. Full stop. These are essentially issues which should have been or ought to have been raised before the civil court, and they're not liable to be. And then the position of the respondent for as the owner of the land cannot be altered in a writ petition, where the challenge is limited to the land acquisition notification dated 21/8/2019, as well as the award dated 1/6/2020. Full stop. Such an attempt would amount to a collateral proceedings against the respondent for as regards his right title and interest for the land in question, which is not permissible in law. Full stop. So next, just at the end, so for the reasons assigned above, the court does not find any merit in the writ petition, and the same is dismissed. In the IA, right? Dita Senior Counsel for the applicant, Mr. M. Katul and CEC for the respondent number 1, and Mr. D. Kamrup, Learned Counsel for the respondent number 2. The view of in this 48 for the parties. 48. No, he's for respondent for the opposite parties. I'm mistaken. Applicant, the applicant, and Mr. Katu would be for all the opposite parties. Next paragraph. Mr. Kanduk is not there in this. Next paragraph. As the connected writ petition has been dismissed by order dated order passed today, i.e. 16/9/2024, comma, this the application stands closed. What is this 168 for? 168 is an appeal.
No, it's a different. It's not this case.
No, here some mistake is being committed. In land acquisition. 168. You listed again. Huh? Yes. You listed 160. You're writing 168. I 168. This matter appears to be connected with appeal 1, AP of 2021. Full stop. As the said earlier, appeal number 1, A1 has already been disposed of by judgment. This earlier appeal is disposed on what date?
Which one?
Earlier appeal 1.
Earlier appeal is.
Sorry, we have the record.
Yes.
On 21 to 2022, come on. This interrogative application stands closed. This stands closed. Or-
I'm deeply obliged, my lord.
It'll take 2 days time to
I know it's okay.
what you call to make it online. I'll not be able to do it.
Sorry for troubling one matter. I think my learned friends all are sitting here also, some other case. There is matter item number 28, Mr. Doloi is here. Jadov Doloi for Union of India. That is 2018. There was some urgency which was taken to Guwahati also. Thereafter, it was transferred here being urgency in this matter. I'll not trouble today, my lord.
Can wait till tomorrow.
No, tomorrow, my lord, I will start. If he has some problem, let him, someone will note down. Because it was taken
No,
to
because
Guwahati.
I can't keep it parted in these.
No, because your lordship is sitting for 2 weeks. 2 weeks your lordship is sitting.
No,
What
but
I'm
I'll not-
requesting,
Mr.
I
Das,
know. I'm
Mr. Das,
requesting.
I am, please understand my predicament. I can't keep it parted.
No, it's okay, fine, my lord.
You choose a date.
Because it will not be possible to, my understanding, it will not be possible one day to argue this case.
No, because I
That
have
is why.
difficulties. There is
No,
a-
suppose your lordship spills over. That's why I requested the court. They why not keep for 2 days continuous in this matter. So if it not tomorrow also, maybe on 2019, 20, 24,
You
25.
just see, Mr. Roy
No,
is
only a
man-
request is being made. Request after puja, it will take long time. It has gone twice. Guwahati, it came back.
To agree to for a date.
Now, my lord, I think, why did my senior counsel agree? Let it come after the vacation.
No, that's why I have.
Before vacation, lot of.
That's why I have got problem, my lord. 2018, not a single.
I agree, rest of the things, maybe keep for 2 days.
No, it's not vacation. I am telling. Then my interim application should be heard. Let 80% be paid by them. I have no objection. No, because there is under 40, army has taken back. We made an application. Application on the ground, we argued the matter, said 80% to be paid under 43. Not a single funding has been paid. Not a single. My lord, thrice the matter was taken. No.
In the land.
No, my lord, I will tell your lordship.
Don't agree with us.
No,
They
I-
have not asked for the land.
No,
State government has taken a whimsical some decision. That is a different issue. Central government never asked.
My lord, I will.
Because long argument is
Keep
required.
it a date because I
No,
don't
no.
want to be.
Let it be
straight
on,
away.
my lord, I'll just proposing. If the friend has a problem this week, let it be on 24th, 25th, 26th, any day. No problem, my lord. 24th, at least that accommodation my learned friend should give, my lord. 24th, 25th, there is no problem. Let it be a stay. Because lot of my lord argument was advanced in this. My learned friend was there.
No, because
We accommodate my learned friend when he was not in abroad.
Mr. Das, knowing you and knowing Mr. Yadav, if it can't be settled here, I think Mr. Nama will make
Malad-
arrangement. He will have
For,
a.
for me, my lord, that is not
No,
the issue.
no.
My lord,
I'm not, that's not what I'm saying. I'm saying that you will make arrangements so that they can have arm wrestling competitions. somewhere.
let it be better after puja, my lord, so that you can complete the
I
ritual,
agree.
everything, my lord.
Yes. 7, 8
Any
November.
date, my lord, no issue. For me, any date, my lord.
7, 8
But
November.
only problem is what
Please
my.
agree to whatever.
I will not agree.
Okay, what are you?
7th of November.
No, any date, any date.
No,
after
why
puja.
not?
No, kindly fix a date among you.
No,
sir.
that's why I'm
Because
saying.
I don't have
No,
any
why you are
problem.
saying-
I don't have any problem.
I want this next week.
Next week,
Yes,
Vikas,
then,
I will not-
my lord,
I think there are 5 other matters which
Yes.
were fixed for today. They may be listed on any date convenient to you after 10th or on 6th and 7th. Because they are also long, because your lordship, they will also take
6th and 7th
6th and 7th.
of,
No,
no,
I
6th
said
and
no,
7 is a
29 and
vacation.
20, 30.
6th and 7 is a vacation. You see,
26.
This is your item, no?
just a moment.
The lordship, these items are.
Yeah, just a moment. Let them.
Yes,
My
my
lord,
lord, I
I-
give it to my senior
my lord,
counsel.
he has some problem. 24th, let it be on 25th and 26th of this month. 25th and 26th. He has some problem. My learned friend, genuine problem. 25th, 26th, I'll adjust somewhere. Even there are cases of APSC fix, I'll adjust because these are topmost priority was given. 25th and 26th of this month.
Let it be 26, 27, my lord. 25th I'm having.
Okay, fine.
26, 27.
26, 27.
Yes.
Well, the Navam has got a limited because our whole case is Union of India and between us.
No, my.
Yes.
State, no.
No,
I don't
state
agree.
government.
State government,
Let me,
in the name of governor, they have acquired the land.
Right.
Let we have the such. Such is a long argument is required.
No, that's okay,
Yes,
because I
yes,
don't
but
want to
we
hear
don't
the
know the
argument
merit of
now.
the case.
20,
My lord,
26 and 27.
26, 7, 27.
26, 27.
Okay,
Yes, Thursday.
okay, as due to positive time matter could not be, item number
26,
28.
20, but due to positive time matter could not be taken up today,
27.
as agreed to by all sides, list on 26, 9, 2024.
If it is roll over to 27.
26.
26 and 27.
Item?
Item 25, 26, 27. And then items 29 and 30. Again, your lordship, these are long matters, so a day suitable, preferably after 7th. Since 26th, I was available, but no, gone. Third also is okay for me, your lordship, third and fourth.
Lordship.
Yes.
Lordship, if I may, Lordship, item number 29 and 30. Lordship, it may come up on the 25th of October,
Just a
September.
moment, just a moment. We are on something else.
So
Item
he is
number?
requesting that for 25th, but then 25th it will not be possible for me. I am willing to come on 26th. But you have taken just now long matter,
Yes.
so it may not even come up. The term may not come for on 25th. So I suggest third or.
No,
third
these are
and
too
fourth.
close to uncomfortable zone. It's just before vacation. We can't give.
So just after vacation I'm saying after that, any date that your lordship thinks.
Because
Going to push the
22nd.
also. just after
22nd,
lunch.
22nd.
22nd, okay. Same order. For the positive time, 22nd. This is item numbers?
22nd of this month?
No, item numbers.
25, 26 and 27.
No, 22nd is not suitable. October, you are saying
October,
October, that's okay,
Ah,
that's okay.
This is item number 24, 25, 26, 27.
5, 26, 27 and 29 and 30.
Or 29, 30 is connected.
No, 29, 30, 25, 26, sorry, 25, 26, 27 are connected with each other.
Okay.
The two separate patches you are not.
Okay, 29, 30, then make it. Make it on same day, 22nd of
Same days.
October.
Or you can keep 2 days, your
Lordship.
lordship, because the 25th,
Yes.
Lordship,
26th,
I will have
27
a
will take.
problem. Lordship, I'm appearing for 29 and 30. Lordship, if 29 and
Of-
30 make item number 29 and 30, they are connected matters. 29 and 30, Lordship. Lordship, if it may
October.
come up on 21st of October, Lordship.
Yeah, that's okay for me. They can come up on 21st and 24, 25, 26, 27 can come on 22nd. That's fine.
Okay, 29, 30, make it 21st October. And this other matters 24 to 27, when
On 22nd.
22nd.
Madam, 24 is separate, madam.
Huh?
24, item number 24 is separate.
24 is separate.
25, 26.
Madam, may I mention item number 24? I'm for the respondent, madam. Madam, I have taken the consent of the counsel for the petitioner, madam. Madam, maybe list it after puja break.
Lordship, maybe
Okay.
the earlier items fixed date and high up on the board, your lordship. Just they can be taken up just after lunch.
No, we are not fixing the list.
I can, madam, puja break.
24.
Your lordship, I am for the petitioner, your lordship, in this
Make it-
case.
Make it 28 October. 24.
Puja break.
Lordship,
Yes.
Your lordship, I am for the
item number, Lordship.
Your
For the
lordship,
bank,
item
we have
number
given a date of 28.
24, I am for the petition. Yes, your lordship. Highly obliged.
28. Monday.
Highly obliged, your lordship.
Okay. Item number 20 and 21 lawsuit. 20 and 21 lawsuit. They will be taken up tomorrow.
21.
2021.
Is the matter about?
This is eviction matter lawsuit.
Huh?
Eviction matter lawsuit. And this IA 20 is a vacation interim order. It's coming up for the first time today lawsuit. So may taken up tomorrow lawsuit.
This IAU.
I is by me lawsuit.
This is for?
Vacation the interim order lawsuit.
Who is for the respondent?
I am for the respondent. Lordship,
Just see item 20.
now only I have received a copy of the IA. Time to reply. If I listen after vacation also.
Very good.
Yes, I need to file affidavit.
Yeah,
Very
look,
good.
the district hospital.
You are aware of the recent judgment by full bench of the.
Uh,
Are you aware of it?
Lordship, actually, respondent, they have yet to file their affidavit in opposition also.
Already filed.
You see, please understand
I
what
have
I'm
not,
saying.
I have not
you
received
heard-
any copy of the affidavit.
Have you heard what I have said?
Lordship, it will be difficult for me to,
Have you heard what I have said?
yeah, that's.
No. So please don't respond without hearing us. Correct. 226.3 will operate after 15 days from today. I'm putting you to notice. You want after vacation? Article 226.3 he operates within 15 days from the court first taking up the matter. Now please take a decision and tell us you want the matter after.
Yes, I need
Okay.
after vacation.
Okay. IA Civil. Heard Mr. Stapin, Senior Government Advocate. As well as Mr. D. Boje, Learned Counsel for the opposite party. Next, the opposite party is the writ petitioner. In the WPC 292 AP of 2024. Next, this interlocutory application has been filed for modification or the alteration of the order dated 26 passed in WPC 292 AP of 2024. Full stop. By the said order, as an interim, the eviction order 23/7/2024 was stayed. Next paragraph. The has put the counsel for the opposite party to notice that as per the prescription of Article 226 within bracket 3, as interpreted by the full bench of this court, ex parte interim orders would stand vacated
Lordship,
on expiry of 2 weeks which will start operating from today. The learned counsel for the respondent, opposite party insists that the matter be taken up after Durga Puja vacations, i.e. after 21/10/2024. Next paragraph. As per the law already laid down by this court, by the full bench of this court, as the interlocutory application has been taken up today, i.e. 16/8/2024, the interim order, it is provided that the interim order would only operate for a period of 2 weeks from today, and thereafter would automatically stand vacated. Next paragraph, list the matter on 23/10/2024.
Lordship may pray that the interim order, whether it has been again, because I am unable to have a clarity on that.
Oh, I am very clear. I told you, I gave you notice. This interim order would vacate on expiry of 14 days from today. That will be automatic. That will be legal interpretation which we have already made. That's why we put you to notice, but you insisted that the matter be taken up after Puja vacation. We can't help it.
Lordship, if interim order is vacated, then Lordship.
No, I'm not vacating it today.
Yeah.
This will operate for 2 weeks from today.
Yeah.
On expiry of 2 weeks, it will automatically get vacated. Please make it very sure. Have a copy. Yes.
I would like to mention one item, item number 23, may be taken up on 18.
What is the item for?
23, item number 23.
What is that for? What is the item?
This is matter relating to disqualification of Panchayati living agreement.
Okay, on 18th.
Sir, if I may make one submission, please.
Since I have reason.
Okay.
ले लिया ले गया तीनों का ले गया ना नहीं नहीं Betul. Itu bahasa saya mengundang di depan. Apa mbak? Jauh dari mana? Jauh dari mana? Undang dulu.